let this matter be placed. On mediation. लेटर है ना ऊपर में आज एक्स ब्लैक एक्स की तरह से आप अपने साथ में किसी आदमी को इसी काम के लिए प्लानिंग करेंगे आपको दोनों आदमी कम से कम फ्लैट तो दिखना चाहिए ना जब वो भी नहीं दिखेगा
Item 24, second appeal 96 of 2013.
Maybe say
at the request of the council for Jharkhand, let this matter be placed for mediation. Just a minute. Office is directed to place this case immediately upon receipt of mediation.
Item 25, second appeal 464 of 2015.
Let this matter be placed for mediation. Same order.
Item 26, second appeal 503 of 2015.
Same order. पिछले टर्म का जितना भी मीडिएशन रिपोर्ट फेलियर रिपोर्ट आया है फाइल कहाँ है सो फॉलो अप मीडिएशन रिपोर्ट फेलियर होने के बाद फाइल डिलिस्टेड 3 साल बाद लगेगा केस
Item 27, second appeal 535 of 2015.
Same order.
Item 28, second appeal 538 of 2015.
Same order. Mediation? We are sending it. They will issue notice and proceed accordingly. They have their own procedure for it.
Yes.
If even a couple of cases are settled in mediation, it's an achievement.
Item 29, second appeal 1 of 2025.
The learned counsel for the respondent has submitted that the applicant is not ready for mediation. The respondent is not ready for mediation. Record eyes.
जी.
You are for respondent number? Sole respondent.
Yes.
Service is complete now.
Yes. Notice आया था उसी पे.
Your file का color.
Yes.
The service upon the sole respondent is complete. Pose this case for final disposal on the 23rd.
20th.
Case गया हो जाएगी. रिकॉर्ड आ गया, पार्टी आ गया, बात खत्म. टाइम लगेगा, हो सकता है सेम डे नहीं टेक अप, एक आध हफ्ता में. There is a likelihood कि मैटर नहीं टेक अप. मरने का इंतजार नहीं करना. मेरा ऐसा सोच है जिसमें पार्टी रेडी है, केस रेडी है, उसको कर देना. अदरवाइज वी आर सीइंग सब्स्टिट्यूशन का कहानी.
This case from supplementary list item 1, second appeal 131 of 1998.
कल का एक मैटर था.
Tablet in person he has appeared. The respondent has appeared in person.
Yes.
Last order they can.
Yes, yes, I remember. Where is he now?
Probably he has engaged someone. This
Whom he has engaged? Whom has he engaged? वही ना, वो तो हम जान ही रहे थे. आज बोलेंगे कि हमको टाइम चाहिए फाइल पढ़ने के लिए. Are you there, madam?
Yes,
You have entered appearance.
Yes, Your Ladyship.
Have you entered appearance?
Yes, Your Ladyship. Yesterday only I filed the complaint.
No, on the last date only I told the litigant that don't ask for time. And your counsel, if he comes and asks for time, that he wants to file.
Yes, Your Ladyship, but I have just received it yesterday itself.
Who will argue the case?
Moreover, Your Ladyship, the difficulty is I have only received.
Who will argue the case? You will argue the case?
Yes, Your Ladyship, but
What do you want?
Your Ladyship just received the file.
You have received the file, you have received the records.
Your
Is there
Ladyship,
anything you are
the
receiving?
second appeal, the entire petition I have not received. I have just received 2 grounds and 1 additional question, substantial question of law that was filed. Your Ladyship, on proof basis, I can show that to you as well.
No, I don't want a proof. I'm just figuring it out. How do I help you to get ready? You need some assistance from the court to get ready. How do I assist you to get ready in the matter? You just what do you want from me?
Your Ladyship, I have filed the wakalatnama for respondent number 1.
Grateful.
The-
Yes, what else?
The remaining respondents will come here to.
We are not bothered about remaining respondents. If they do not come, that's their headache. Service is complete. We will not bother about other respondents. It cannot be a device for adjournment.
Yes, Your Ladyship, I completely agree. But Your Ladyship, I am also genuinely saying that.
Yes, I am also genuinely trying to help. Very genuinely. It is a partnered case.
Yes,
In the
Your
midst of a partnered case, your client had taken the file from the counsel. On the last date, he appeared in person and said that he will engage a counsel. Right? Now you have been engaged. So,
But Your Ladyship, just after, Your Ladyship, after one, I can just pray for one time to just at least to be
I will
fair.
give you one time for tomorrow. Tomorrow. I don't know beyond that. I can't see. I can see only tomorrow with my short sight. It's a partnered case. Why do you want to? What do you want? You just tell. क्या चाहिए? Memo of appeal चाहिए. Memo of appeal इनको provide करो. और क्या चाहिए बताइए?
बाकी तो कोर्ट रिकॉर्ड से they can get it.
Just tell me. What do you want?
Time, Your Ladyship.
Should the office go to your house?
No, your ladyship.
What do you want? The records are here. Records will be retained. You can read it till 8 o'clock at night. I will not stop. That is available. Okay, this courtroom, this office is open till 8 o'clock. The point is that you have to find time to read it. Okay. So records will be detailed. You can read it throughout the day. But records are in a very bad shape. This is of a case of 1998. It cannot be scanned.
That we will help her in giving
जो भी
it.
आपके पास है आप दे
दे
दीजिए.
देंगे.
ठीक है. चलिए आज थर्सडे
और
नेक्स्ट
बाकी
थर्सडे.
बाकी LCR में they can get it from the court records. It is
Record you can see, but somebody would be there to help you because छूने से पेट फट जा रहा है. Right? These are all the सूट कब का?
सूट तो बहुत पुराना है. 88.
Were you born in 88?
96.
So just imagine.
Let them.
Just imagine. This suit is of 1988 when you were not even born.
There are two matters in between the same party, same family. One is partition, one is title. The title suit has been placed for 9th of February.
I remember. I'm
Or
just indicating to her that on the next day time will not be granted.
अभी भाग के दौड़ के आई है.
ये दो सेकेंड अपील दूसरे में भी वकालतनामा फाइल कर दी है.
Only in this one.
Right? What about the next?
they have not taken the action.
No.
They are
Oh, उसमें no objection नहीं.
continuing with this.
Yesterday only he has given it back.
In that case, he will argue the already engaged ones. Ninth product. How many years have you been in practice?
3 years.
I can guarantee you that I'll give you an experience of 10 years if you argue these matters. Your experience will be equivalent to 10 years if you argue these two matters. So far as second appeal is concerned. They know about it.
I am confident that she will be.
She has already appeared in court number 9 without against me, and she has won.
Oh, that's good. So on 9th,
9.
with the consent of the learned counsel for the parties, pose this case for final hearing on 9th. To be taken up with second appeal number.
That is not happened.
Will not tag it. Which case has to be heard first?
This one, because this is a pattern,
Okay.
it would be better that this is heard first.
For final disposal?
Uh,
The
As
learned
first case itself.
the learned courtmaster is directed to retain the records received from the court concerned and make it available to the councils for inspection and reading as in when they टाइम तो पता नहीं उसको कुछ नहीं दिया. I don't know. पाठवे के ऊपर अपने साथ
But last stage it was mentioned that this would be taken up as first.
okay, to be taken up as first. आपका लिटिगेंट थोड़ी है, करेक्ट? जो है वहाँ पर आप ही है ना? हाँ, तैयार करवाइए, अपना केस को तैयार करवाइए. ठीक है, 9 तारीख को है, केस को रेडी कराइए. ठीक है?
This case from Kerry list item 27, second appeal paper 1 of 2006.
Yes, please. कल का जो पार्टनर मैटर है उसको हम लोग को टाइम नहीं दिया, वो भी तो सारे डिस्कस और के हिसाब से नहीं चलता है. पिछला जो लेटेस्ट पार्टनर होता है वो दैट इज अ प्रोसीड्यूर, अगर मान लीजिए 3 केसेस ऐसे होते हैं तीनों साइड से, पहला केस वो होगा जो हम लेटेस्ट ठीक है, यस
Then admitted appeal minus the substantial portion of your being by order dated 8 March 2006. Sorry, by order dated 5th March 2009. First being whether the Court of Appeal below has committed error in reversing the findings recorded by the trial court without complying provisions of Order 41 to 33 of CPC. Second being whether findings recorded by the appellate court suffers from the serious perversity in as much as for non-consideration of evidence in its true perspective. Lordships, the appellant hearing, his father was defended before the learned trial court, and the suit was filed by the respondent number 1.
He was the sole defendant.
Lordships, one of the defendants, contesting defendant. Lordships.
Defendant number.
He was defendant number 1. Guru Bachchan Singh.
The suit was dismissed.
The suit was dismissed by the learned trial court, and the other defendants who were before the learned trial court was the deputy commissioner and respondent number 3, Gura Q. He was the person from whom the plaintiff purchased the land. He was
Defendant number.
the defendant number 3, Lord.
Defendant number 3.
The former defendant.
Plaintiff purchased the land from defendant number 3.
Lord.
By registered sale.
By registered.
Dated.
Dated projects. Dated 23/11/1990.
23/11/1990. Who is defendant number 2?
Deputy Commissioner of West Singh, Tribals.
Both are tribals. Parties are tribals.
No, madam. Defendant number 1 is not tribal. He is claiming the land mallards through his
The
second wife.
plaintiff is the tribal.
Plaintiff, he is mallards. He is tribal and he is purchased land from tribal.
Yes, purchased the
Purchased the
land.
land from tribal. He is also tribal.
Plaintiff and defendant number 3 are tribals.
Lordships. And they have said that they have obtained the permission from the deputy commissioner, which we have also
After
obtained.
obtaining permission.
Lordships. And so far as defendant number 3, Gurati is concerned, he is claiming the land in question on the basis of so-called partition of the suit property, which was the original property of the recorded tenant.
Who is the recorded tenant?
The recorded tenant is Chota Pandu Ho, whose name was recorded, my lords, in the service settlement of 1917.
Recorded tenant is Chota
Pandu Ho.
Pandu Bo.
Pandu Ho, Lord.
Pandu
Ho, H-O.
Pandu Bo.
My lords.
His name was recorded in service settlement of
My lords, 1917.
1970.
1917.
1917.
Thereafter, my lords,
Just note, this record of right was exhibited.
my lords,
Exhibit
this, my
number?
lords, exhibit 8 is the exhibit numbers.
Okay. Then what happened?
Thereafter, my lords, they are saying that in the year 1964, again service settlement was held, so far as the concerned land is concerned, and in that service settlement, name of Buratir along with the other co-sharers were mentioned in the Khatihan notes.
Name of
Defendant number 3.
Chota Pandu.
Chota Pandu who
Name of defendant number 3
Lordships.
and
Other co-sharers Lordships.
sharers and descendants of Chota Pandu.
Chota Pandu. But these descendants, the genealogical table or genealogy has not been proved by
Just
the
a moment.
and
Just this is exhibit number
exhibit 8 by 8.
8 by 8. Okay. It must have been mentioned son of Chota Pandu in the record of right.
That is the discrepancy in the claim, and in one of the paragraph they are saying that they are the son of
In the exhibit.
the exhibit. Lordship, there is no direct mention of Chota Pandu being the.
It must have been mentioned
Ascendant
defendant number
of the-
3 son of such and such.
No, that is not mentioned. That is also one of the points which was considered by the trial court that genealogy has not been proved by the plaintiff. Whether the Chota Pandu was the ascendant of the defendant number 3. Although at one paragraph he is saying that the Chota Pandu was father of defendant
We'll
number
come to that. We'll come to the details later. Now let us see where is the cause of action. Now this is about defendant number 3.
But this is about the plaintiff. They are
What?
saying that thereafter the plaintiff purchased in the year 1990.
Purchase in the year. Okay.
And so
What
far as
about defendant number 1?
so far as defendant number 1 is concerned, he is saying that he was in the possession of the land in question since 1950.
1950.
And thereafter,
In the capacity of.
without there being any title, he was only in possession of the
Okay. He claimed possessory right.
possessive.
1950. So you are the defendant number 1.
And
Who is the
thereafter,
appellant?
thereafter, Lordships, in the 1961, the defendant is claiming that the second wife of the defendant purchased the land from Bamiyaho by registered sale deed.
Just a moment. Second wife of defendant number 1.
Lordships, who was a tribal lord.
Purchased from
Bamiyaho.
Bamia.
Bamia, B-A-M-I-A.
A-M-I-A. Ho.
Lordships.
By registered sale deed.
By registered sale deed after obtaining the
Dated.
necessary permission.
Dated.
Dated is 13/10/1961.
13/10/1961.
Exhibit would be exhibit C.
Exhibit C. By taking permission from
Permission from the Deputy Commissioner.
DC. Then
Then, Lordships, the defendant number 1 is claiming that the second wife died in the year 1966 on 12/1/1966,
okay.
and thereafter, he inherited the said land, and his name was recorded in the municipal survey of 1972.
This is exhibit.
This is Lordship's exhibit. I 1 by 1 and I by 2
I 1 by 1
and I by 2.
Just a moment. Please hold on. Let me just capture this. Essay number 111 of 2006. This appeal has been filed against the judgment and decree dated 8/3/2006. Within bracket, decree signed on 28/3/2006, patent rules, passed by learned Additional District Judge, Fast Track Court 5, Chaibasa, entitled appeal number 29 of 1995 / R. number 12 of 2003, whereby the first appellate court has allowed the appeal preferred by the plaintiff and has set aside the judgment and decree dated 17th of June 1995, within bracket, decree signed on 12/7/1995, passed by learned Munsif Chaibasa, entitled suit number 6 of 1992. The title suit was dismissed by the learned munsif. The appeal was allowed, and consequently, the defendant number 1, who is the contesting defendant, is the appellant before this court. This appeal was admitted for final hearing by order dated 5/3/2009 on the following substantial questions of law. There is no modification, no further substantial question of law. Is there any modification?
There is no modification.
Yes. The learned counsel for the appellant has submitted that the plaintiff had purchased the property from defendant number 3 by registered sale deed dated 23/11/1990 after obtaining permission from the Deputy Commissioner. The sale deed is marked exhibit,
Exhibit 1, Lord.
exhibit 1, and permission is also exhibited.
Lord's permission.
The within bracket exhibit 1.
Exhibit 4 in Lordship is a paid copy of the said case. Permission for selling the property. Exhibit 4 is the order sheet.
Exhibit 4 is the order sheet granting permission for executing the sale deed dated 23/11/1990. He submits that since the plaintiff and the defendant number 3 are tribals, therefore, defendant number 2, Deputy Commissioner being a necessary party, has been made party in the proceedings. The learned counsel further submits that it was the case of the plaintiff that the recorded tenant with respect to the suit property is Chota Pandu Ho, whose name was recorded in survey settlement of the year 1917, within bracket exhibit 8. Thereafter, in the year 1964, in survey within bracket exhibit 8/8, the name of defendant number 3 and others appeared as co-sharer, and defendant number 3 claims to be the descendant of Chota Pandu Ho. The learned counsel has submitted that the genealogy was not proved, and therefore the relationship of defendant number 3 with Chota Pandu Ho was not proved. However, so far as the case of the appellant within bracket defendant number 1 is concerned, the learned counsel submits that he was in possession of the property since 1950. The specific case of defendant number 1 was that the second wife of defendant number 1, namely Bamia Ho, had
Lord's, the name of the wife was Sumi Kui, Lordship. Bamia Ho, from whom she purchased.
name of the wife was
Sumi Kui.
Sumi, S-U-M-I.
K-U-I.
K-U-I. So his second wife, namely Sumi Kui, had purchased the suit property from Bamia Ho in the year by registered sale deed dated 13/10/1961 within bracket exhibit C after taking permission from the Deputy Commissioner. However, the second wife expired on 12/1/1966. Consequently, the defendant number 1 inherited the property, and his name was also entered in municipal survey of the year 1972 within bracket published in the year 1972 within bracket exhibit I-1/1 and exhibit I/2. Yes. Now tell us what are the issues framed by the learned trial court and what are the findings?
The judgment of the learned trial court projects starts from page 33 of the memo of appeal. Issues are yes, at internal page number 21. 22 it starts. Is the suit maintainable? Is the first question, first issue. Second one is the suit barred under the law of litigation. Second one is issues. Third was has the plaintiff acquired any right, title, interest in suit by virtue of deed of sale dated 23/11/1990. Fourth was has the defendant number one perfected right, title, and interest over the suit property by way of adverse possession. Fifth was has the plaintiff any cause of action for the suit, and sixth was has the plaintiff entitled to any relief or relief. So far as the finding as far as the learned trial court is concerned,
Deed of sale is 23/11/1990.
issue number 4,
There is no issue on genealogy.
there is no issue on genealogy, but there is no issue so far as the right, title, interest of the plaintiff by virtue of the said sale deed. If the vendor did not have the right to sell off the property, he would not have the right even by virtue of the sale deed. That finding has been recorded by the learned trial court. So far as genealogy part is concerned,
Where is it?
that is at internal page number 35.
Yes.
Further, if I may place the entire
Yes,
page.
please read it.
Further, the plaintiff clearly stated in the claim that thereafter the suit land has been recorded in the name of Gura Ho and his brothers and other 4 sharers as plot number 2968 under parcel number 29, according to the Survey Settlement 1964 Exhibit 8. In Moja, Ilya Macha and the said suit land has fallen in the share of Gura 3, the performer defendant. PW3 also stated in paragraph 6 of his evidence that about 50 years back, the partition took place in the family members of Chota Pandu Ho. But the Khatian Exhibit 8 verified that in the year 1964, the property of Chota Pandu Ho, son of Ramu Ho, devolved upon his heirs. The plaintiff did not prove the genealogical table of the heirs of Chota Pandu Ho, son of Ramu Ho. However, the Hal Survey Settlement of Moja Dilya Marcha, which was published in the year 1964, has verified that the heirs of Chota Pandu Ho, son of Damu Ho, Pandu Ho, Singrai Ho, Gura Ho, Rajnara Ho, Damu Ho, son of Bamia Ho, Damu Ho, son of Chota Pandu Ho, Lakshman Ho, son of Ranku Ho, Bara Ho, Bamia Ho, Exhibit 8 also verified the property of Chota Pandu Ho, son of so and so, bearing Khata number 29, were in possession of the aforesaid persons. The said exhibit also clarified that in a member of Ho community, it is very common that there are 2 or 3 persons of the same name in one family. The sale deed exhibit C, bearing 1199 dated 13/10/1961, has been executed by Bamia Ho, son of Ranku Ho. None of both persons, Bamia Ho and Ranku Ho, are recorded in the Hal Survey Settlement of 1964. Exhibit 8. These facts clarify that Bamia Ho and Ranku Ho are the heirs of Chota Pandu Ho. Exhibit 8A, the Survey Settlement Khatian clarified that the recorded tenant of the land of Khata number 29 is Chota Pandu Ho, Damu Ho in the 1970. Clarified or by mistake, the exhibit has been marked as Exhibit 8 instead of Exhibit 8 by A. 1917 would be Exhibit 8 by A. The 1964 settlement would be Exhibit 8.
In Hal Survey Settlement 1964, Exhibit 8.
And 1917 Khatian is Exhibit 8 by A.
Yes, it is mentioned as Exhibit 8 by A only.
Perhaps Lordships, I have, while Lordship was noting down the exhibit notes, I have informed that it is Exhibit 8. That may kind of be
Exhibit 8 will be 1964. Or Exhibit 8 by A would be 1917. Correct?
On the other hand, in the 1964, the Survey Settlement Khatian, Exhibit 8, shows that Damu Ho is the son of Chota Pandu Ho of same Khata number so and so. Exhibit 8 further clarified that another Damu Ho is son of Bamia. In absence of the genealogical table of the recorded tenant of Chota Pandu Ho, son of Damu Ho, whose name has been recorded in 1917, the it cannot be believed that Bamiya Ho son of so and so was not the heir of opposite Chota Pandu Ho. The opposite facts
And
verified.
the name of Bamiya Ho is also mentioned.
It is mentioned.
Son of Bamiya.
Bara Bamiya Ho is also mentioned. Also, it cannot be ascertained whether both of them, whether they are the descendants of the original recorded tenant.
No, you see,
But-
it is mentioned that they are the recorded
They are the
tenants.
recorded
They are
tenants.
the descendants of the recorded tenants, but in one family they have persons with the same name.
Same. So whether they are the same person who is
So there is one person called, there is one Rajendra Ho and Damu Ho, son of Bamiya Ho. And there is one Damu Ho, son of Chota Pandu Ho. Okay, anyways, then
So the
In
opposite
absence of
facts,
genealogy.
in absence of the genealogical table of the recorded tenant, Chota Pandu Ho, son of Damu Ho, whose name has been recorded in the year 1917, it cannot be believed that Bamiya Ho, son of Damu Ho, was not the heir of the aforesaid Chota Pandu Ho. The aforesaid facts clarified, page number 29 begins, Bamiya Ho, son of Damu Ho, was also heir of Chota Pandu Ho, son of Damu Ho, who was recorded tenant of Khata number 29 in the year 1917. It is admitted fact that the land of Khata number 29, bearing plot number 2188, area 6 decimals land, which was recorded in the year 1917, Khatian, is the same land which has been recorded in the Hal Service Settlement of 1964. Under the Khata number 29, plot number 2968, area 6 decimal, and it is the suit land. Exhibit 8 clarified that the suit land has been shown in the possession of Bero Banaya Ho. In view of the Bero Bamiya Ho is no one but he is son of Nangu, and being old man, he has been named as Bara Bamiya. The opposite fact clarified that the sale deed number so and so dated 13/10/1961, which is Exhibit C, executed by the right person who is the heir of Chota Pandu Ho, son of Damu Ho. The opposite fact gives more strength because the plaintiff did not examine any witness who are the heirs of Chota Pandu Ho. In absence of genealogical table and also non-examination of any family members of Chota Pandu Ho, son of Damu Ho, falsified all the claims of the plaintiff as mentioned in para 6 and 15 and 16 of the claim. So, in the plaint, in one of the paragraphs, the plaintiff is saying that Guratui was the son of the Chota Pandu, and in another paragraph, he is saying that he was the grandson of the Chota Pandu.
What is this, the learned counsel for the
The
defendant?
learned advocate for the defendant clearly admitted during his argument that Suni Kui's name could not be recorded during the service settlement of 1964 because the defendant could not get registered sale deed. However, the said error has been rectified during the municipal service settlement which was published in the year 1971-72. However, the opposite facts can also be said to be true that Bamiya
So name of Sumi Kui is not there.
is not there in the service settlement.
Right? Is not there in the survey settlement. And who was claiming through Sumi Kui? The
The
defendant number
defendant
one.
lordship.
The
Defendant
defendant number one was
defendant
claiming
number
through.
The
So
applicant
name of Sumi Kui is not there.
It
So
is
in
not
absence of a name,
there.
how the court is coming to a finding that she is that there was an error in recording this?
Yes, because of the registered sale deed which they have not challenged till date. Even in the civil lordship, they have not challenged the registered sale deed, which was after the due permission from the learned authority concerned. The sale deed was executed. Even the service settlement of 1971-72 has not been challenged. Therein also the name of the appellant, the original defendant number one was recorded in the service settlement of 1971-72. And
Though the name of this vendor was not recorded.
vendor was not recorded in the service settlement 1964, but thereafter it was rectified in the year 1972. And
So that is not a rectification, that is
that is
municipal
municipal
service.
service settlement also.
It's
But in
not
the
a
municipal,
rectification.
but in the municipal service settlement has mentioned that he is in the possession of the land in question and he is paying the rent for the said
You
land.
see, entry in record of right has got lot
That
of
is not
evidentiary
precise.
value, but
That we
not
understand.
municipal service.
That we understand. That
So the name of Sui, who is the vendor of the defendant number one, is not mentioned.
it is not mentioned. But we are not
Then how
claiming.
does, sorry,
But we are not saying that the defendants they have all the documents or legally they are entitled to the land in question. But the fact remains that the plaintiff has filed the suit It's for the plaintiff to establish that he has the right title interest over the land in question, because for that matter the issue was framed that whether the plaintiff has the right title and interest over the property in question, because the fact, it is admitted fact, Manoj, that the
You are
defendant
claiming
number
adverse
one,
possession also.
that was the in the pleading, but
You are
that
claiming
was
adverse
not,
possession.
but that was not proved by way of the evidence of pleading.
So you can plead both adverse possession and title.
That is there, but the fact remains that they are in possession of the land in question for last 50, 60 years. It is admitted fact of the parties as well as the finding of the
Here
trial
long
court.
possession means adverse possession.
No, that has to be proved by way of reading as well as evidence. 12 years of knowledge in that. All have to be
From which date you are claiming adverse possession?
1950 he is saying that he was in possession. 1961 he is saying that his wife purchased the land. And 66 he came into the possession of the land by way of inheritance through his wife. And 72 his name was recorded. But Maras, I am not in that matter. I am saying that the plaintiff, they are claiming the title by way of registered sale deed, and that sale deed is on the basis of Khatiyan, only on the basis of Khatiyan. That name of one of the co-sharer was recorded in the name of in the Khatiyan of 1964. Apart from
That is
that,
enough.
Khatiyan Maras being a record of right, that cannot be the sole basis for determination of title of the property.
But the descendants of the recorded tenant's name is mentioned. In the meantime, there is no sale deed.
No, Maras, but
In the meantime, there is no sale deed.
there is no sale deed, Maras.
So therefore, the name of son of recorded tenant, that is also mentioned in the record of right.
But genealogy has not been proved. Maras.
Maybe that the genealogy has not been proved, but it has been proved that the vendor of the plaintiff belongs to the family.
No,
There-
it has not
there
been
is
proved, Maras.
material.
It has not been proved, Maras. It has only been proved that in the 1964 settlement their names are there. So it can be, because it is a finally published record of right. So there is a presumption that their name is recorded rightly by the concerned party after due verification.
It is not only that, it is also mentioned the son of such and such. That is
But-
also mentioned.
But Maras, so far as Guratri is concerned, there is Maras parentage as well as the linkage with the Chota Pandu. That is not clear from the Khatiyan.
The name of the
1960.
entire family is mentioned.
But he is claiming to be the grandson at one time.
Maybe grandson or whatever son. But he is belonging to the family. And what about you? You are claiming from a third person and there is no link that she is from the family.
But the fact matters remain that it is a registered sale deed prior to the sale deed which they have.
Maybe prior is
They have
not
not.
prior.
They have not challenged.
If the vendor does not have title, why should they challenge? If on the face of it the vendor does not have a title, then he cannot pass any better title than what he has.
But my lords, the plaintiff has also not been able to prove the title, lords, merely on the basis of my lords, name being recorded in the service settlement. But I have got the judgment that record of rights does not create any title in favor of any person. They should have brought the person concerned, the recorded tenants, descendants, or any other documents. But because in the 1917, the Khatiyan, the name of Chota Pandu was recorded. Thereafter, lordship, when the land stood vested in the state in 1950, lords. Thereafter, they have not stated so that they have got the land by way of settlement or they were paying rent. Coupled with the rent receipt, their names are recorded in the Khatiyan. There is no such pleading, there is no such evidence to that. Merely on the basis that the name of the co-sharer as well as the vendor of the plaintiff is mentioned in the Khatiyan. The learned first appellate court has held that they are the title of the property. And
Let's finish reading this because there is a judgment of reversal.
page 28.
Continue.
However, the opposite facts can also be said to be true that Damia was son of Ranku had right to execute sale deed. That is Exhibit C in favor of Suniti, because the Exhibit G, which is the certified copy of the order sheet of SRA case number so and so, which are filed by different scheduled tribe members to return the properties which are in possession of defendant number 1, never realized this said issue, never raised the said issue which has been raised by the present plaintiff, that Suniti was the fictitious lady. That is also their claim that she was fictitious lady. And Bamia Ho, son of Ranku Ho, has got no right, title, and interest over the sued property to execute the said sale deed. It is also very significant to note that the native places of the plaintiff is not in the village Tiliamacha. Being an outsider, he is trying to falsify all the opposite documents. It is also significant to state that all the opposite cases are decided in favor of defendant number 1. Hence, its statement as stated in paragraph 1 so of the claim by plaintiff are totally false and disbelieved in in light of the opposite discussed facts and in light of the opposite documents. Rather, in light of the opposite documents, plaintiff is stopped under the law to challenge the genuinity of the opposite seal deed number so and so dated 13/10/1961 executed by Bamiya in favor of Sumi. It has already been established that defendant number 1, Guru Bachan Singh, was occupier of one mistress Mikui and said property purchased by the said Guru Bachan Singh in name page number 31 begins this mistress Mikui. However, it has been already been established from the evidence that said Mikui died in the year 1966. The said fact can falsified only by the evidence of family members of Sumikui can say that she was not mistress or wife of the Guru Bachan Singh. In absence of all those evidence, the suit property can easily be said to be succeeded by the occupier of Guru Bachan Singh. On the other hand, the present plaintiff can never succeed the suit property which was purchased in the name of Sumikui by registered till the Exhibit C. The said fact has also been corroborated by defendant number 1 in para 14 of his law of examination. It is, however, admitted by the defendant number 1 in paragraph 9 of his written statement that the suit land has not been recorded in the name of defendant number 1 in the Chaibasa Municipal Service Agreement 1970-71 and same has been numbered as Khata number 19 dot number 483.
Has not been recorded.
Has been recorded. Has been. And the said fact is corroborated to the exhibit I. The documents exhibit 99 by A, 9 by B, which are filed by the plaintiff, and the documents exhibit D, G, exhibit G by 1, exhibit G by 2 verified that the heirs of recorded tenant of original Khatiyan of 1917, exhibit 8 by A never challenged the right title interest of defendant number 1 from this year 1961 to till year 1991. All the said documents in favor of it favors the right of the defendant number 1. That thus the opposite documents establish that present defendant number 1 is the rightful owner of the suit property by virtue of sale deed number so and so dated 13/10/1961. So this issue is decided in favor of defendant number 1. Issue number 5 and 2. This issue can be proved by the documentary evidence as well as oral evidence. Only in this issue, it is to adjudicate whether defendant number 1 became able to prove his claim by way of adverse possession or not. The plaintiff avoid in para 10 of his claim that since purchase of the suit land, plaintiff is in physical possession over the same and he has fenced all around it, and for construction of his residential house, the plaintiff collected house building construction material over
What is the finding? You are not claiming now adverse possession, right?
No, that
What is the finding?
finding Lordships is page number 44. Hence, in view of the opposite facts of oral and documentary evidence, verified that occupant number 1 is the occupier of the suit land since the year 1960, and his position over the suit plot is also established through these documents. The position is open and continuous and also hostile to the interest of Buraho, also who is vendor of the suit plot. Although this said Exhibit 8, which is certified copy of the Khatiyan published in the year 1964, also classified that said Buraho, son of Bamiya, was not in possession of the suit property, suit lot number so and so, Khata number so and so. Thus, according to the said fact of evidence, verified that after expiry of 30 years, defendant number 1 has also perfected his title over the suit property.
How does the courts record that although the exhibit A, 8, which is a certified copy of Khatiyan published in the year 1964, also clarified?
Because Lordship, the possession was in favor of some other person that has come.
Name of Buraho is mentioned?
Exhibit 8, Lordship. It is mentioned, but so as possession is concerned, page number 37, it is stated, Lordship, that Exhibit 8 clarified that the suit land has been shown in possession of Pero Bamiya.
No, Buraho's name is also there.
Name is there, but so as
Buraho's name is also there.
Gura, whole name is there, but the defendant number 3 is Gura Q. Also, although he has not said so that both the person are one and the same only, or his title remains the same. But
No, how
so far
does,
as
although the exhibit 8, which is the certified copy of Khatiyan published in the year 1964, also clarified that say Buraho, son of Bamiya, was not in possession.
because also it was shown that the possession was with Bero Bamiya in Exhibit 8. Although name was
They have
recorded.
mentioned that it is
Page number 37, Lordship, the fourth line, fifth line, Exhibit 8 clarified that the suit land has been shown in possession of Bureau Bamia.
Just come to page number 35.
35. The names of the other
Yes,
names have been
in
recorded.
exhibit 8 has been mentioned.
Good.
Clarified that Chota Pandu ho, son of Damo. Years of, it is mentioned in there that years of Chota Pandu ho, son of Damo. Then Pandu ho, Sindhi ho, Kora ho is mentioned.
They are only legal heirs of Chota Pandu.
Yes.
So far as Gura Ho is mentioned, Manoj,
Yes.
it is mentioned that he is so-called the son of Bamia.
No, where it is? It is Kora ho straight away.
That's in the fourth word which is mentioned in that line. Gura Ho, Rajnara Ho, Damu Ho, son of Bamia.
That is separate. Kora ho is separate.
Manoj.
Gora ho is mentioned as a separate person also.
That's
And there is another Gora ho, son of such and such.
But so far as Manoj, the linkage with the Chota Pandu, that has not been established.
This particular exhibit 8
It must show
reflects
that-
the descendants of Chota Pandu. Firstly, in the meantime, there is from say 1917 till 1964. Right? It is not your case that after the purchase in 1961, the property was recorded in somebody else's name. You are claiming purchase from in the year
1961.
1961. It is not your case that your name was entered.
It was not.
So it is not mentioned in Exhibit 8 that you remained in possession in 1964 also.
But
Your possession is not established from Exhibit 8. Rather, it is negated by Exhibit 8.
But Lordship, 1972 settlement shows that I was in possession.
1972 is a separate thing. But in the year 1964, you were not in possession.
In the service settlement, it is not mentioned.
You are, yeah, and they are claiming by virtue of safety taken.
1990, 1990. They are plaintiffs claiming by way of 1990, and
No,
we are claiming
vendor,
by.
the vendor of the plaintiff has purchased when?
He has not purchased the land.
He is the-
His name was recorded in the service settlement.
And he transferred it.
He transferred in 1990.
And your vendor's name is also not mentioned here.
That one name is mentioned as Bamia Ho.
Bamia, who is your vendor?
Bamia Ho is the vendor of Sumiti, who is the so-called second wife of the Indian.
Bamia, who is the vendor of Smriti in the year 1961.
But issue number 3, if I may please, last issue of the learned trial court which is discussed.
So they have, the court has held you in possession since 1960.
Lordship.
Since 1960.
Appellate court has also held that the plaintiff has not been able to establish his possession of the land in question and the defendant.
When was the suit filed?
In the year 1995, 92 Lordship. 1990.
What about the first appellate court?
Issue number 3, if I may please, Lordship.
Yes,
Last.
issue number.
Page number 45. The plaintiff stated in para 1 of the claim that he purchased the land from an Gura person of Bamia of Moja so-and-so to register CLD dated 23/11/1990 after obtaining permission under section 46 of the CNTR from the appropriate authority. Plaintiff further pleaded that suit land was originally recorded in the name of Chota Pandu, grandfather of said Gura Q, under old Khata number so-and-so bearing plot number 2188 in the year 1917. The said suit land recording the name of vendor of the plaintiff, Gura Q, and his co-sharers under Khata number 29 bearing plot number 2968 in hard service settlement, which was found finally published in the year 1964. The plaintiff further pleaded in the plaint that said that suit land fallen in the share of Gurat vendor of the plaintiff, and he is the rightful owner of the said suit land, and he was all along in exclusive possession of the suit land. The said deed through which the plaintiff purchased the suit land has been marked as Exhibit 1 with objection. However, it is clear that the government of the plaintiff that he purchased the suit land from rightful owner Gurat who had got this exclusive possession over the said land according to Hall Service Settlement published in the year 1964.
Goratyu and Gorahu are one and the same person.
That they have not said. That is also different. Gurat is the party concerned, dependent, who was the defendant and whose name was mentioned in the sale deed. And so far as service settlement is concerned, Gurat is mentioned. The plaintiff has not said that both is one and the same person. But on the result of Khatian published in the year 1964, which is Exhibit 8, clarified that suit land was in possession of Bara Bamia Co. Hence, the said document, Exhibit 8, falsified the government as made in the plaint that vendor of the plaintiff was in exclusive possession of the suit land. However, it was already been established during the adjudication of the above issue that Bamia Hosan of Kanpur already sold the suit land in the year 1961 by sale deed number so dated 13/10/1961, was also the heirs of Chota Pandu, son of Damu. It is also great significant to note that vendor of the plaintiff Gurat is also the son of Bamia Ho, and it is the prevalent in the tribal people of Singhbum district that there are so many persons of one name in one family. This fact that clarified that predecessor of Gurat already sold his suit land in 1961 to Sumi Kui. Thus, the right of Gurat to sell this suit land again in the plaintiff name has already been seized. So, the Gurat son of Bamia is not the rightful owner to sell this suit land against the name of the plaintiff. And the entire argument made by the plaintiff is false and cannot be believed. Exhibit 8 itself falsified the evidence of plaintiff. PW9 as stated in para 3 and 4 of this evidence. Evidence of PW3 itself clarified that the present plaintiff never came in possession of the suit land. The plaintiff, the evidence as adduced by PW9, the plaintiff in para 26 clarified that he is the literate person and is employed in Punjab National Bank. He purchased the suit land in the year 1990 to a registered sale deed. Before purchasing the suit land, he must have knowledge that suit land is under municipal area. Exhibit G5 clarified that by government notification number 4830 dated 29 January 1961, the suit land came under the jurisdiction of Chaibasa municipality. The plaintiff should have knowledge that the municipal survey operation was conducted in the year 1970-71. Before purchasing the suit land, the plaintiff must have to verify that in whose name the suit land has been recorded during the municipal survey settlement of 1970-71. Because the plaintiff was purchasing the suit land in the year 1990. He must have verified the name of the rightful owner of the suit property from the municipal record. Khatian I, which was published in the year 1970-71, after Chaibasa municipal survey settlement, verified that the suit land was recorded in the name of defendant number 1 as a Basari Haq. It is already been established that defendant number 1 is the rightful owner of the suit land.
Basari Haq?
Yes.
Basari is to Basarwa. Something like that.
Based on possession.
Based on possession.
The evidence as abused in para 37 of his plaintiff evidence cannot create his right title interest over the suit land that he never saw the Khatian, which was published in the year 1970-71, and he had no knowledge about the said Khatian. PW9 stated in para 46 in his evidence that he unloaded the stone over the suit land by truck, but he could not say even that when in which year he unloaded the truck. The evidence of PW7 as stated in para 10 of his cross examination that Bulanchand Gentil wanted to unload the student brakes, and during the time the dispute started and the defendant number 1, who is the rightful owner of the property, obstructed in unloading the stone and brakes over the suit land, and the plaintiff could not succeed in unloading the stone and he was drive out Exhibit 4 also corroborated the opposite evidence as it used with PW7 in paragraph 6 of his evidence. The evidences of PW3 also corroborates his facts on the point of possession over the suit land by the plaintiff, and the evidence clarified and established that the plaintiff never came in possession of the suit land. The government, as pleaded by the plaintiff, that after the purchase of the land, it is under the peaceful possession is wrong and false. That the opposite facts of evidence as well as the documentary evidence established that according to the Municipal Service Settlement of 1970-71 of Chaibasa Municipality, defendant number 1 is the rightful owner of the suit land as Bazari Haq, and he has got his right title and interest over the suit land. Defendant number 1 is only entitled to transfer the suit land to any other person. This said Guratiu, son of Bamia Ko, had no right title interest over the suit land to transfer the same to present plaintiff. Thus, the sale executed by said Guratiu in favor of plaintiff cannot have any binding effect on the right title interest on the defendant number 1. Said fact of evidence also clarified that the former defendant number 3 executed and executed a registered fake sale deed, exhibit 1 in favor of the plaintiff after obtaining permission of sale for the said land from the concerned authority by suppressing the documents, exhibit 9, 9 by N, exhibit 10. However, it is also established
What is
that
exhibit 9, 9 by N and 10?
that that is not the SAR case which was previously filed alerts for restoration of land.
Who filed?
Alerts the so-called descendants of the original recorded plaintiff.
That is the plaintiff.
Not the plaintiff alerts. The original recorded plaintiff Chota Pandu, both his descendants.
They filed a restoration case against whom? Against the defendant number 1.
For the same land or
Against the defendant number 1.
that we have the exhibit 9 and 10.
This is SAR cases, right?
SAR case 1 of 1986.
Then
However, it is also established through the evidence produced by PW3, PW4, and PW7 that the plaintiff tried to obtain possession over the suit and forcibly after execution of sale deed exhibit 1, which is fake 1. The defendant number 1 objected and restricted in result proceeding under section 144 CRPC and under section 107 CRPC started, which are finally dropped. Exhibit A by 6 and A by 7 establish the aforesaid facts. The documents as filed by the plaintiff, exhibit 9 by B, clarified that the present plaintiff got his name mutated after the execution of the aforesaid fake sale deed, exhibit 1 and got the correction slip in his name, exhibit 7, by the order of the Anchal Adhikari Sadar Anchal. But the said order has been satisfied by the learned coordination appeal number 6 of 1999-91. The certified copy of the said order, exhibit E by 4, clearly established that the said facts. The plaintiff also filed revision petition against the order of the learned LRDC, while mutation revision number so exhibit G by 5 clarified the said fact. The said exhibit G by 5 also clarified that the said revision petition is also dismissed by the learned additional deputy commissioner of Singh in Chaibasa, and both parties are directed to seek relief from the competent civil court. Hence, exhibit 3 series the Malgudari rent or receipt has got no value in the eyes of law. Thus, the aforesaid discussed facts clearly established that the former defendant number 3, the vendor of the plaintiff, was never rightful owner of the suit land and never possessed the same. Similarly, after the execution of fake sale deed exhibit 1, the plaintiff never came in possession of the suit land. The aforesaid fact and evidence also established that the present plaintiff never perfected his right title interest of the suit land through the fake and registered sale deed exhibit 1. And this said transaction is the sham transaction defendant number 1 perfectly challenged the aforesaid sale deed exhibit 1 bearing so and so. In this way, by virtue of sale deed number so and so dated 2011-1990, the plaintiff did not acquire entitled interest over the suit land. Therefore, on the basis of the aforesaid discussion, the issue decided against the plaintiff. Again, against this order, not they preferred the appeal. The learned appellate court members recorded the finding, which would start from internal page number 13, which was the first appellate court. Page number 12, issue number 3.
What is the point for determination?
The point for determination was not so specifically framed by the learned first appellate court. The learned first appellate court only deal with the issues which were framed by the learned trial court. No separate point for determination was framed. Finding of the first appellate court start from
He has dealt with issue wise.
issues. Not
Whatever the issues were decided by the trial court, the same issues were taken up by the first appellate court. Right? First, he decided issue number 2 and 4
Yes.
on the point of adverse possession.
Right.
Then he dealt with the
Issue number 3.
documentary, just issue number just 2 and 4 first, and then let us see how does he deal with it. He deals with all the evidences on record, correct?
Right.
Start from page internal page 6. Issue number 2 and 4.
The finding starts from page number 9.
Page number 9 bottom, it is admitted to both parties.
To both the parties that this property belonged to old plot number 2188. It's clear from exhibit 8 by 8 that this plot was recorded in the name of Chota Kanju Ho in the service settlement of 1917. After considering the testimonies of
DW5.
DW5,
Who is DW5? He admits that he
Guru
was
Vasan Singh, defendant number 1.
okay, he was the defendant number 1.
He admitted that he is a Sikh and he was married to Manjeet Kaur in the year 1940, who was still alive in the year 1995. When he deposed before the court, DW5 has also stated that he married with Sumi Kui in the year 1960 in Jaibasa, Gurdwara.
He was married to
He was already
Manjeet
married.
Kaur.
Manjeet.
So
Manjeet
this
Kaur.
Sumi Kui was nobody.
As per Hindu law lordships, she was nobody.
Even
Marriage
as
was not valid.
that marriage was not valid, then how does he become the successor of the property purchased by Sumi Kui?
Not. Now, as per the Hindu Marriage Act 1955, by which defendant number 1 is also governed, he could not have contracted a second marriage with Sumi Kui in case of his early wife being alive at the time. Therefore, no legal marriage was possible between defendant number 1 and Sumi Kui, and she cannot be a legal wife of defendant number 1. Being thereby defendant number 1, DW5 cannot inherit the property belonging to Sumi Kui as a legal heir. The plaintiff's court has also filed Exhibit 6 and voter list of the 1960, which Manjeet Kaur has been shown as wife of DW5. Plaintiff has claimed that Sumi Kui was a fictitious person, but on this point, plaintiff has also filed voter list of illustration so and so, in which one Sumi Kui, daughter of Ramya Deogan, has been mentioned. Further, PW3 has also stated about the existence of Sumi Kui. Further, Exhibit GY8, 9/B, and 10, and Exhibit D, all these prove that Sumi Kui existed, and she died in the year 1966 on 12/1966. Further, I find that defendant has admitted that suit land belonged to Bamia Ho prior to this LD Exhibit C, which is dated 13/10/1961, meaning thereby that the defendant admitted the possession of Bamia Ho over the suit land. Further, I find that defendant also admitted that Sumi Kui died in the year 1966. Further, defendant has failed to prove that Sumi Kui was his legal wife. Therefore, he cannot inherit her property. Therefore, the possession of Sumi Kui over the suit land can be held to be the possession of defendant number 1. Further, DW5 has also stated that he established saw machine over the suit land in the year 1966. Though he has stated that he constructed house over the suit property in the year 1961. And he has filed rent receipt and demand notices regarding the holding number 1 of 2001 2001 belonging to defendant. One notice exhibit F, which is dated 21/9/1960, regarding the holding number 1 of 201, meaning thereby that there was a house in the year 1960 about which this notice was issued. Therefore, it is quite clear that the tax receipt and notice does not belong to the disputed property, since in the year 1960 no house was constructed by the defendant. Therefore, I find that any construction was done by the defendant, it was done in the year 1966. Further, the said the suit land was, as per the statement of defendant, belonging to Sumi Guil Hathir. Therefore, the adverse possession of the defendant, if any, started in the year 1966. Further, the plaintiff has also filed survey Khatiyan of 1964, Exhibit 8, Industry Plot number 2968, is recorded in the name of Gura Ho, son of Bamia Ho, and others. This Khatiyan shows that the Court of Rights was prepared in the 1964 regarding the village Dilia Marcha, and if Sumi Guil was in the possession of this land, then her name should have appeared in the Khatiyan. As per provision of section 46 CND, there is restriction on the transfer of right of Rayyat. Now, consider here, who is the member of scheduled tribes, may transfer with previous consent of DC his right in his holding to another person who is member of the scheduled tribe, meaning thereby a Rayyat land belong to a member of scheduled
See,
tribe.
in the entire judgment of the learned trial court, there is no discussion of these evidences which have been considered by the learned appellate. So therefore, these things have not been, the learned trial court has completely ignored these facts. The Sumi Guil was not the legal, although it was being disputed that she was not the second wife, and she was not the legally wedded wife. It was specifically disputed. But these evidences, nuances of the evidence of the person who is claiming that she was his second wife, itself is indicating that she was not his second wife.
If I may, leadership, one thing from the trial court's order. The trial court also agrees that she was not the wife. It has been recorded in the trial court's order.
Where is that?
Page number 31 of the trial court's order.
Page number 31. Yes, please.
Last paragraph, please. I am quite agree with the argument of the learned advocate for the plaintiff, but the Hindu Marriage Act does not debar that a Sikh member cannot marry a scheduled tribe girl. However, that marriage will be treated as void. Then the second wife will claim inheritance and right title and interest in the joint family property of the Guru Bachan Singh. In this suit, the said Sumi Guil or the illegitimate son or daughters is not claiming the right in the property of the Guru Bachan Singh. So the trial court also agrees that the marriage was void.
That is there in the WS itself. Yes, himself stated that he has a wife who is alive and
Yes. Yes. Para number 29. But for a different reason. The trial court is not saying that during the lifetime of first wife she could not do this. The trial court has come to a finding that the marriage
was void.
However, it is clear that in this suit, the Guru Bachan Singh occupy a mistress,
Yes.
namely Sumi Guil in the 1960, and purchase a suit property in the name of occupier mistress. Benami property in the name of his mistress.
But here we are mainly concerned with the title of the plaintiff.
Yes, certainly.
The defect of the defendant cannot be taken as an advantage for the plaintiff. Even if we are not able to establish our title over the land, the plaintiff will have to establish his title over the land with the way of the legally admissible document. That is it. But if Lakshmi kindly come to issue number 3, that is the main issue.
Appellate court,
Appellate court, page number 12.
which is regarding title of the plaintiff.
Title of the plaintiff.
Which is that page number?
Page number 12 it starts. First, the submission of the plaintiff and defendants are recorded. The finding starts from
Page number 12.
Internal page number 12, issue number 3.
After 11, I have 15. 12, issue number 3. Pages are not properly placed. There is a
case
finding.
finding also starts from page number 14, the last paragraph.
I have
I
found.
have already found that Exhibit C does not confer any right title interest to defendant since Sumiki was not legally wedded by him. Therefore, he did not inherit any property. Further, Exhibit C shows that Sumi purchased the land of Khata number 29 belonging to plot number 2188 from Bamiya, son of Nantuko. But surprisingly, plot number 2188 of Khata number 29 was not recorded in the name of Bamiya, son of Nantuko. In the service settlement of 1917, nor any letter service settlement, therefore, it becomes doubtful. Therefore, it becomes doubtful.
This
But
C is the defendant number 1 stock, right? Sumi purchased this property from Bamiho,
Bamiya, son of
Bamiya,
son of Ranpur.
Rangpur. But surprisingly, plot number 2188 of Khatan was not recorded in
The
the
name of Bamiya, son of Ranpur, in the service settlement of 1970. So 1970 lordship recorded in the name of Chota Pandu, nor any other later service settlement.
So this is discussing about your document.
About my document.
Then
Thereafter, it becomes doubtful that Bamiya, son of Ranpur, has a right title and interest in plot number so and so. I find that Exhibit 8 and Exhibit 8 by 8 shows that such plot in Khata number was recorded in the name of Chota Pandu. On this ground, Exhibit C does not confer any right title interest in this land. But anyhow, Exhibit 1 in the said plot, which has been given a new number 483 in the service settlement of 1972, has been wrongly recorded in the name of Guru Bachan Singh. Because this finding is not supported by any evidence. There is only one.
no, you see, this finding, it is not recorded. This is not recorded in the name of Guru Bachan Singh. Is it
It was
recorded?
recorded in the name of Guru Bachan Singh, but merely the update code is saying that it was wrongly recorded in the name of Guru Bachan Singh without there being any evidence.
Naturally, without any title. Without any title. Because Guru Bachan Singh neither had title through his second wife, nor had title through adverse possession. And the nature of entry is relatable to possession only. Right? Then
Thereafter, my lords,
Exhibit 1.
Exhibit 1 has been duly proved and it was executed after taking permission of the party concerned. Transfer of this deed has a right and interest in the property to the extent of his share. As recorded in the Khatyan of 1964, 1 by 18th in each plot of Khata number 29, including plot number 2968. The plaintiff has pleaded and claimed that plot number 2188, corresponding to plot number so and so of the settlement of so and so, corresponding to plot number 483 of municipal service settlement of 1972, was in exclusive possession and share of Guratiu. But Guratiu or any of his brother or co-sharer of Khata number so and so has not been examined to prove the partition among them. Even Guratiu has been made a party but not examined. A testimony of other witness on this point.
Guratiu has been made party but not examined.
He was not examined. A testimony of other witness.
Guratiu was the co-plaintiff.
He was the performer dependent members from whom the plaintiff purchased the land.
Did he file his written statement?
No.
So he has no objection. He had no objection to the statements made by the plaintiff.
But he has not proved his case also. Right?
That's right. He has no objection. Guratiu has no objection.
Yes. But so far as the title till the year 1990.
Article, a testimony.
A testimony of other witness on this point, including plaintiff, is not reliable on the point of partition between the co-sharer of Khata number 29. Therefore, I find that in each plot of Khata number so and so service settlement of 1964, each co-sharer has right title and interest as per the share mentioned in Khatyan. I further find that as per Exhibit 8, the Khatyan of 1964 regarding the Khata number 29, share of Guratiu in plot number 2968 is 1 by 18. Therefore, I also find that Guratiu could pass on aforesaid share in plot number 2968 with the plaintiff through sale deed Exhibit 1. Therefore, I find by virtue of sale deed Exhibit 1 only 1 by 18 share of plot number 2968 passed on the plaintiff. Therefore, the plaintiff has got 1 by 18 share in plot number so and so to plot number so and so of the year 1972. Further, I find that the plaintiff has failed to prove his possession of this land, but he has right title and interest in this land along with the other co-sharers. Therefore, he has right to possess the same jointly with the co-sharers. The exhibit is in favor of the plaintiff and against the defendant. So far as this finding is concerned, this was never the case of the plaintiff in the plaint or the evidence that the other co-sharers also have the right over the suit property. He was claiming and he was pleading that the suit property fell in his exclusive possession after the partition, which he could not prove. So, my lords, the learned trial court, merely by way of presumption, my lords, has observed, the first appellate court, merely by way of presumption, has observed that other co-sharers along with this plaintiff will have right title interest over the suit property interest. Although those co-sharers were never the party, they were not.
Plaintiff doesn't have a co-sharer.
My lords, it has been recorded, my lords.
It has been wrongly recorded. No, plaintiff doesn't have a co-sharer. The court says that 1/18 share could have been transferred.
But that salary has not been modified, lords, by the learned first appellate.
Salary need not be modified.
That modification
You
needs to be
see,
done.
there is inconsistency in the finding. The court records a clear finding that 1/18 share is recorded in the record of rights.
My lords, but
Right?
merely,
And therefore he could have sold that property.
but
And he
lords,
has sold that
the
property.
relief has been granted beyond the pleadings. The pleading was never of the plaintiff that the other co-sharers had any share of the said property. The case of the plaintiff was that he was the exclusive owner. He got the property by way of partition, and the learned first appellate court made out the third case, which was never pleaded by the plaintiff in the plaintiff.
We'll rectify it. That plaintiff's title is only to the extent of
But lords, we
1/18.
have judgment certificate that relief cannot be granted beyond the pleadings. The
But
pleading-
once the substantial question of law is framed, the nature of substantial question of law,
Lords,
relief can be granted. Why not? It is inconsistent. We are here to rectify it. It is absolutely inconsistent.
No, lords,
The court-
because what the learned first appellate court has done, that
What was the area of the suit property?
6 days.
6 decimal. And what was the area of the recorded property in the record of rights? Total area?
That, so you have to
Tell us, what is the
But-
total area?
it's very good.
His undivided interest has been declared to the extent of 1/18.
But lordship, he has filed the execution case
Right?
for the entire land.
That we are not bothered about executing this. You go and
It's
find it
merely on
out.
the basis of this finding, my lord, that he along with the other co-sharers has the title over the property.
No,
When the other
no,
co-sharers
you
were
just
not.
see the insert, just see the operative portion.
My lords,
The
regarding-
plaintiff has right title and interest over the suit property described in the schedule A to the extent of his share of 1/18.
Lord, thereafter,
Yes.
I find that the plaintiff has failed to prove his possession of the suit land, but he has right title interest in the suit land along with the co-sharers. Therefore, he has right to possess the same jointly with the co-sharers.
You just see the order, the operative portion of the order, what the court has granted.
Thereafter, my lords, we can see
Yes.
the second relief.
Yes, joint
Plaintiff
possession.
is entitled to jointly possess the suit land along with the other co-sharers.
That's right.
So, my lords, the other co-sharers, they have not approached the, my lords,
They are not-
either this
might not
court
have.
or the learned first appellate court, my lords.
They might not be approved, but his share is declared only to the extent of 1/18.
But, my lords, if I
And
may-
your title is completely out. You are nobody on the property.
lords, if I may,
You are nobody on that property.
And
You are
maybe I am
just
in
a
the
land
position-
trespasser.
I am in the possession of the land for more than 50 years.
No,
That is the
no,
admitted case
no,
of the.
no, that is not the admitted case.
But the finding
You
has
just
been
have a
recorded,
note.
lords.
No, the finding has been recorded. That
Lords,
you
para
are-
11, my lords.
You just have a look at it.
Page number 11, lords.
No.
Page number 11. The appellate court has recorded that the construction defending was made by the defendant in the year 1966.
So, in the 1922.
1966, lords.
So, how much period is required for adverse possession?
That is, lords, 12 years.
No, 30
30
years.
years, 30 years. But
So, have you completed 30 years?
there is no pleading to that effect.
No, we have to see, no. Whenever we are seeing adverse possession with respect to property in this area, we have to see the point of limitation. And at 30 years has been mentioned before the trial court also, and here also 30 years has been mentioned.
But, my lords, my submission, if you lords may kindly, my lords, appreciate that the claim of the plaintiff, but I am not on my title. I am saying, my lords, so as title of the plaintiff is concerned, their only claim on the title is based on the survey settlement of 1964. That vendor of the plaintiff was mentioned in the survey settlement of 1964. Apart from that, they have not gotten record any document to suggest
That is enough.
that after the vesting of land,
That is enough.
after vesting of land,
That is
I have
enough.
got the judgment of the Supreme Court as well as the
That is enough in view of the. This is guided by Chotanagpur tendency.
Lordship, but record of rights cannot confer title over any person.
No, but that there is a presumption in connection with record of rights.
But there,
The fact that the owner of the property is the recorded tenant was the owner of the property is not in dispute.
but that has not been proved by
That
the
is not in
plaintiff.
dispute. The record of rights records
But
the entry of his years.
after vesting of the land stood vested in state after 1950. But 1970, the earlier settlement was made. That in that name was Chota Panduga was recorded. But 1964, from 1950 to 1964, the plaintiff has not pleaded how the land stood vested or has he paid any rent to the state and he being in
Paying
possession of the
rent
land.
to the state will not divest or not paying rent to the state will not divest the title of
But there has to be settlement of land post
Not
1950. Because their land stood vested in the state. How
Not
then they will have to show how they came into the
Not
ownership
this.
and the possession of the land.
Not
They have
this.
got the judgment. They claim that record of right cannot create a title over the property. Even the Khatiyan, even if the name is mentioned in the Khatiyan, that does not create a title over the property. And so, as record of right under CMT Act is concerned, it is only prepared to the extent of fiscal purpose of.
No, that is not that. It is not that. There is a presumption in connection with record
There is a
of
presumption,
rights.
but
Presumption of correctness of entries made in the record of rights.
that is there,
And it is recorded in the record of rights that it was in possession of the legal heirs of the original tenant.
Yes.
And one of the legal heirs of the person whose name has been recorded in the record of rights is the vendor of the plaintiff.
But the record of rights only shows the possession as well as the payment of rent to the
No,
landowner.
you are absolutely mistaken. Chotanagpur Tenancy Act
But
has
when
its
you
own
please
law
note section
analysis.
84 of the CMT Act, the content of the record of rights. Section lordships, the 80 start also the record of rights and settlement of rents. Page number 89. Power to order survey and preparation of record of rights. State government may make an order directing the survey to be made and record of rights to be prepared by the revenue officer in respect of lands in any local area, state or tenure or part thereof. Notification in the official gazette of an order under subsection 1 shall be conclusive evidence that the order has been duly made. The surveyor shall be made and the record of rights shall be prepared in the prescribed manner. Section 81 lordship, the particulars to be recorded. Where an order is made under section 80, the particulars to be recorded shall be specified in the order and may include either without or in addition to other particulars, some or all of following, namely the name of each tenant or occupier, b the class to which each tenant belongs, that is to say whether he is a tenure holder, Mundari, Kakut, Khatidar, settled raier, occupancy raier, non-occupancy raier, having good Khati right or under raier, and if he is a tenure holder, whether he is a permanent tenure holder or not, and whether he is.
Are you reading the entire statute or you want to make some submission?
I want to show, my lords, that section 81, it only shows, my lords, that the rights and liabilities of the recorded tenants and, my lords, the raiers is only prescribed there. It does not show that the raiers will have title over the land merely because it is mentioned in the record of right.
That's right.
And lordship, so far as order 41 will continue is concerned, if lordship may kindly have that is also one of the constitutional of law, that it provides, my lords, that the trial court, the trial court could have passed some decree and that has not been passed, but that could be considered by the learned first appellate. But if lordship may kindly have order 41 of the CPC. Power of the Court of Appeal. The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, or to pass or make such further or other decree or order as the case may require, and this power may be exercised by the court notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties might not have filed any appeal or objections, and may where there have been decrees in cross suits or where two or more decrees are passed in one suit, be excised in respect of all or any of the decrees, although an appeal may not have been filed against such decree. So that it prescribed that if any decree which could have been passed by the learned trial court, and if that has not been done, so the learned first appellate court can pass such decree under Order 41 to 33 matters. But that is with respect to the parties who were before the learned trial court. And here in this case, the learned first appellate court has passed the title, has passed the declarations of as title and interest over the full property of other co-sharers as well, who were never the party nor examined before the learned trial court. And merely on the basis of Khatiyan matters, I was submitting that the ownership or title cannot be proved by the plaintiff to show his title over the land.
You want me to cite the judgment?
Matters by my senior sister.
Your resistance is not required.
Let me take the judgment.
Okay, place the judgment. But don't place anything from
No,
here.
I am not arguing the matter. I just have one submission and then I'll place the judgment. The entire case, whatever is argued is argued. Only I can summarize in one line. Whether the relief which has been ultimately granted by the appellate court could have been granted. That's the only thing. Now, kindly assuming on the basis that this is an ex parte suit, my defense is zero. I do not have any defense. The relief was what, and the prayer was something else. Relief is something else. The sale deed of the plaintiff is also in question. As per the trial court, the appellate court says that your sale deed is also bad because the original vendor could have only given you undivided share of 1/18th. That's the only relief to that extent. Now today, the question is how it will be executed. I am in possession. The plaintiff is not entitled to the entire land. He or she is only entitled to 1/18th of undivided share.
What is the total area of the land?
Area of the land.
And what is the area mentioned in the cell deed? And what is that exhibit? Exhibit 1. Data is the exhibit.
Area is 6 decimal, suit land.
The suit land is 6 decimal. What is the total area of the property?
What? Khatiyan.
Khatiyan, what is the total area?
That is also not a million because what exhibit 1. Now, whatever be the land, it may be 18 acres, but which is that 1/18th undivided share, there cannot be any demarcation. So today, by virtue of this decree,
You have whatever you have to say in the execution case, but not.
I am saying this decree itself is but bad in law. Such a decree relief could not have been granted. This amounts, what is it? This amounts to rectification of the sale deed. Kindly have section 26 of the specifically defined. In absence of the parties to the sale deed, the sale deed cannot be rectified. Today, in effect, the sale deed itself has been rectified. Changed. The sale deed of a particular piece of land now says no, this is undivided 1/18th. Such a relief is impermissible in law, irrespective of whether I have title or no title. Now kindly take section 26.
So it is exhibit 1.
Yes, no. So it is exhibit 1. A specific portion, demarcated portion of 6 decimals of land was sold to me. The option finding is at the bottom of second page, otherwise 6 decimals. Now, one more point, in this sale deed, there is a reference of a partition. And because obviously the sale deed without a recital of partition could not have by means and bounds, this theory of partition has been negated by the appellate.
There is no issue framed.
Not required. It's in plaintiff's case. Therefore, I'm saying if no issue was framed, then a relief can't be based on that finding. If no issue was framed, it is then for the lower appellate court to recast the issues that whether this is permissible. So that's an error of law. You have not taken me by surprise. You say that this sale deed. Now, kindly allow me just to read the last portion. What has the trial court done? Trial court says that the plaintiff has a right to possess it along with the co-sharers. Appellate court, the first amendment. That's the finding. He is not in possession, but is entitled to 1/18th share of possession. So, rewriting the sale deed, this amounts to absolutely rewriting the sale deed in absence of the vendor. And just one more fact, since your lordship has exhibit 1, the witness, kindly have a look at the vendors has signed, put a signature. But PW7 has said that the vendor was illiterate and used to put fingerprints. That's just a doubt which should have been
That-
created.
We are not on
Yes,
that.
but that's a
That is
fact.
not the scope.
Let me assume that the sale deed has been duly executed. Let me proceed on that assumption. My lordship is rightly not going to do that. My only point is that the relief granted is inverse. In absence of any prayer, in absence of any particular pleading, in absence of issues, and in absence of evidence. Because the vendor did not come up to give evidence, he was the author. That is recorded also. Yes, sir. So just one line minutes of the lower first appellate court judgment. Just page, the last, second last page, page 15.
Page
15, parallel page 15. Ninth line from the bottom, where the stamp is, your lordship will say exhibit 1 is referred, and then I will do it, therefore I find, the ultimate finding. Therefore I find by virtue of the same deed exhibit 1, only 1/18th share of plot 9/296, which is not correct, passed on to the plaintiff. Therefore plaintiff has got 1/18th share in plot number 2968, corresponding to plot number 483 of survey settlement of the year 97. Therefore, I find plaintiff has failed to prove his possession. Further, I find that plaintiff has failed to prove his possession over suit land. But since he has right title and interest in the said property along with co-share, therefore he has a right to possess the same jointly with other co-share. The issue is decided. So it doesn't amount to rewriting the entire exhibit 1. Now, there is only one provisional law which permits a modification in a sale deed by a court, that is section 26 of the specifically. The intention of the parties is a relevant fact. Number one, it has to be a suit between both the parties. A relief claim that look here, we agreed for this, but unfortunately there is an error, rectified. That's the suit. But that requirement is also not being satisfied to gather the intention. Here the intention of the parties of sale deed was to give him 6 decimals of divided land. Something contrary to the sale deed has been done. Therefore, the plaintiff's right title interest, the sale deed actually having come to a finding that there is no partition, the vendor had no right title interest to give him undivided share, the sale deed itself is unenforceable.
There is a finding of the learned first appellate court that there was no partition.
Yes, just before that, in that same case. Just before that, your lordships have seen, kindly come to this exhibit 1, kindly come to the first paragraph, after 5 lines from the top, 6 lines from the exhibit 1. May I read now? Exhibit 1 has been duly proved and it was executed after taking permission of the authority concerned. Transfer of this deed has right title interest in the property to the extent of his share. As recorded in the Khatiyan of the year 1964, that is 1/18th in any each plot of Khata number 29, including plot number 2968. The plaintiff has pleaded and claimed that the old plot number 2188 corresponding to plot number 2968 of survey settlement 1964 corresponding to plot number 483 of municipal survey of the year 1972 was in exclusive possession and share of Gorathui. But Gorathui or any of his brothers or other co-sharers of Khata number 29 has not been examined to prove the partition among them. Even Gorathui has been a party in the suit but not examined. A testimony of other witnesses on this point, including plaintiff, is not reliable on the point of partition between the co-sharer of Khata number 29. Therefore, I find that in each plot of Khata number 29 of the survey settlement 1963, each of co-sharer has right, title and interest, but as per share mentioned in Khatiyan, I further find as per exhibit 8 in Khatiyan of the year 19 regarding Khata number 29, share of Gorathui in plot number so and so is 118. Therefore, I find that Gorathui would pass on the aforesaid share to plot number 2968 to the plaintiff through sale deed. So there is no partition, he can only pass on 180 of 2968, not of the 6 decimal. So how is the sale deed being now enforced? That irrespective of whether I am a rank encroacher, I am not even setting up my defense of title. I have one submission to say that a marriage between me and the lady can be void, but that does not make the title of the lady defective. My marriage may be void, but the title of the lady does not. That's the approach. That since your marriage is bad, the title is bad. How is that possible?
That is not there. That is not there.
That's no. I can show that.
Both the things have been taken care of.
Correct, but they
That
say
she was not the wife. Right?
marriage is not there.
Once marriage is not there, she cannot pass the title.
She cannot.
This is the finding.
Correct.
We don't
But
bother
her-
about whatever
But her
her
title does not become bad.
Her title has also become back because she has not been able to prove that she was was one of the recorded tenants.
The same thing applies to them. Then how? The only thing is not the same. The trial court therefore says the genealogy is bad.
He has already read it. You have not.
Yes, I am therefore not arguing.
So you
anything.
argue whatever judgment you want.
So my only submission is that the relief granted is impermissible, could not have been granted. As your lordship pointed out, there is no issue frame. If it is an undivided share, a person can only convey undivided share. There is no problem. But the court cannot rewrite a sale deed. That's the first one. The plaintiff has to stand on his own legs. He has to prove his title. Here in this case, as per the first appellate court itself, the plaintiff has not been able to prove his title of the land in question. This is on the principle that the plaintiff has to prove, but I'm just giving it here. So we know paragraph 15 to 19 reiterates. If your lordship wants, I can just show paragraph 15. It's a 4-line paragraph, not much. It is strike law. It is strike law that in a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration, and the weakness, if any, of the case set up by the defendants would not be a ground. That's the settlements. Now your lordship will come to the next judgment, which says the relief beyond pleadings. It was never the case set up that I am entitled to 1/18th of undivided share of plot number so and so. Not even 6 decimals. Kindly come to paragraph 8. Paragraph 8 of this judgment, but the later portion of paragraph 8 at the last page, notes, kindly come. If your lordship will permit. The last portion, notes, we highlight. The last page 545 is a part of paragraph 8 only. As has been stated, the defendant reverts that the claim is written statement and pleaded that the business always belonged to him and as owner. There was thus no plea that the business was benami for Shivanna. We also find that the parties did not join issues on the question that the business was benami. On the other hand, the point at issue was whether Shivanna was the owner of the business and the tenancy rights of the premises where it was being carried out. It is well settled, having regard to the law, having been laid down by this court in so and so and so and so and so and so, that a decision of the case cannot be based on grounds outside the plea of the parties, and that it is the case pleaded which has to be found. The High Court therefore warned. Here, it was nobody's case that there has been no partition. Rather, the case was on partition, that he has 1/18th share, that the sale rate can be sustained. It's clearly beyond pleading. One more judgment is same, but it is much more elaborate. Paragraph 16, 17, 18. Coming to address the second issue, while this court is not apathetic to the predicament of the respondent grandparents, it is a fact that absolutely no relief was ever sought by them for a change of surname of the child to that of the first husband / son of respondent. It is settled law that relief not found on pleading should not be granted. If a court considers to grant or grants relief for which no prayer or pleading was made, depriving the respondent of opportunity to oppose the resist, it would lead to miscarriage of justice. Then again, the Trojan judgment and Bharat so and so judgments have been referred. Now that Trojan is quoted portion very clearly says it is well settled that the decision of a case cannot be based on a ground outside the pleadings of the parties, and it is the case pleaded without any amendment. So here we never sought that. In fact, to my surprise, they should have also come up in appeal and said how the lower appellate court, having accepted it, today they can't evict me from the entire piece of it. Now, as my friend has already argued and shown that the entire claim of the plaintiff is purely and simply based on the fact of the revenue records, record of rights prepared in the 1964 service settlement. Beyond that, no other claim to title of the vendor. Now, revenue records is a part which can establish title, but not the only, because the purpose of revenue records.
Parameter.
22, 30, I have written on documents 21, 31, 31, 22, kindly see. It is strike law that revenue records are not documents of title. In fairness, today, recently the Supreme Court says even sale deed by itself is not a document of title. There has to be other. Ownership has 9 components. They all have to come together to establish ownership. Today there may be a sale deed like this. This is a prime example that the person sold the land 6 decimals. The court itself, I know, he could not have sold this 6 decimals. So and by itself, the revenue record is merely for the purpose of who will collect the rent, who will pay the rent to the government. Just last one on survey settlement. This is also from our High Court only went up to the Supreme Court. This is from our High Court. And minutes based on survey settlement of 1964 itself. Kindly come to paragraph 5. Same minutes, kindly see. There was a contention that the property in question is my self-acquired property, and in order to support, he was relying on survey settlement. Paragraph 5. The contention raised by the appellant is that since Mangal Kumar was the recorded tenant in the suit property as per the survey settlement of the year 1964, the suit property was his self-acquired property. The said contention is legally misconceived since entries in the revenue records do not confer title to a property, nor do they have any presumptive value on title. They only enable a person in whose favor mutation is recorded to pay the land revenue in respect of the land in question. As a consequence, merely because Mangal Kumar's name was recorded in survey settlement of 1964 as recorded tenant in the suit property, it would not make him the sole and exclusive owner of the suit property. The appellants have failed to adduce any evidence whatsoever apart from the survey settlement of 1964 to establish that the suit property was the self-acquired property of so and so. Now, this I believe is also from Chaibasa, yes, the same district where we are saying. So therefore, the 1964 survey settlement, Supreme Court is not a document of title. Just to sum up, the plaintiff's claim is based that he has a sale deed from one of the recorded tenants. They have not been able to show that the recorded tenant otherwise had title which flows to him. As I said, 64 settlement by itself is not a document of title. Assuming some title has flown from that title deed, that plea or the sale deed itself being defective to the extent it is void could not have been modified by the lower appellate court, the first appellate court, to grant the relief that has been granted, because that is clearly beyond PDs and minutes, clearly a relief which was not sought for. I have been taken today by surprise that how could this be? Because Exhibit 1 itself, if your lordships have seen, says that there has been a partition. So against the finding, it has given a record against the fact recorded in Exhibit 1, the lower appellate court has given a finding. So therefore, this appellate judgment has to go. That's all. Can I personally?
The parents don't have got it. You have to say something on this?
Yes.
First, hold on for a while. The Learned Counsel for the Appellant has placed the judgments passed by the Learned Trial Court as well as the Learned First Appellate Court. And he has submitted that though the defendant has not been able to prove his title with respect to the property, nor the defendant could prove adverse possession with respect to the property, but it was for the plaintiff to prove his case, correct? The Learned Counsel submits that neither the plaintiff could prove partition nor the plaintiff could prove title of the vendor of the sale deed executed in favor of the plaintiff. He has also submitted that survey settlement of 1964 by itself is not a document of title. The Learned Counsel has also referred to Order 41-33 of CPC to submit that relief beyond pleadings could not have been granted. यही ना आपका submission?
And it's also submission that the getting marriage to be declared as void does not make the sale deed in favor of Sumikui to be invalid.
The learned counsel has also submitted that that does not.
Because Lordship, ultimately, if the title passed on to her, the same property could not have been
The
transferred.
learned counsel has also submitted that merely because the second marriage of the plaintiff was found to be void,
Defendant number 1, Lordship.
or
Second
the
marriage.
defendant number 1 was found to be void, the same cannot be a reason to hold that the title of the vendor of the defendant number 1 was defective. He submits that once the property was already passed,
The title of not defendant number 1, the title of vendor of
vendor of the defendant.
Sumikui, Lordship. Because
Okay, title of the vendor of Sumikui was bad. He has also submitted that once the title with respect to the suit property was already passed, there was no occasion for a second sale deed with respect to the same property. The learned counsel has also submitted that the relief which has been granted by the learned first appellate court, that the plaintiff would have right, title and interest over the suit land to the extent of 1/18 of his share, and that he will be entitled to jointly possess the suit land along with other co-sharers, is also defective, inasmuch as no such relief was sought for by the plaintiff.
and also no pleading was there.
And also there was no pleading to that effect. Rather, the pleading was that the vendor of the plaintiff acquired 1/18 share.
The pleading was that he was the exclusive owner by way of partition.
That's
He acquired
right.
the property.
The vendor of the
not
plaintiff,
1/18, not 1/18, Lordship. The entire 6 decimal land he acquired. That is the
1/18 of the recorded property.
that is not the pleading. Pleading only says that the suit land 6 decimals. That's after partition fell in his exclusive share, and he was the rightful owner of the 6 decimal land.
The case of the plaintiff was that after partition, the suit land fell in the share of the vendor of the plaintiff, which was sold to the plaintiff. That is all. The learned counsel has relied upon the following judgments. Bracket 2014, bracket close to SCC 269, para 15 to 19, 2022 SCC online SC 928, bracket 1977, bracket close 3 SCC 532, bracket 2024, bracket close 13 SCC 553. सबका पैरा बताया क्या?
Because we have mentioned the para of
हाँ yes. ये सारे में पैराग्राफ ऊपर लिखा हुआ है, ठीक है? 24 हो गया, एक ब्रैकेट 2019 ब्रैकेट क्लोज 10 SCC 259, कुछ छूटा तो नहीं, सब हो गया? सब में पैराग्राफ लिखा हुआ कर देगा, उसको सबको कोट भी कर देगा, इसको जरा क्या करें? However, during the course of argument, it is not in dispute that the property belonged to Chota Pandu Ho, correct? Whose name was recorded in the record of rights of the year 1917. 1917. And both the plaintiff claimed that the suit property was sold by the legal heir of the recorded tenant, and defendant number 1 also claimed that the suit property was sold to क्या Sumikui, to Sumi Kui by the legal heir of the recorded tenant. Correct? Both of them, they claim that it was sold by the legal heir of the recorded tenant. चलिए, अब आप क्या करेंगे?
Yes. Leadership, before I proceed, leadership, an objection was raised that the entire land is under execution. The leadership will only have the decree which was prepared by the appellate court. It is very clear in the decree itself. And this decree is under execution.
Yes.
Leadership, we kindly see the last part, the suit land described in schedule to the extent of his share to 1/18. The plaintiff is also entitled to jointly possess the suit land along with other co-sharers. And this decree is only under execution.
Your Lordship may kindly have a moment the execution application is there. The schedule of the property.
आपको सुन लिया ना? Please don't disturb.
In that regard, they are saying that only that
Execution में क्या रहा है is none of my concern.
As Lordship, they were submitting that in the execution only that extent.
To submit to each other. I'm non-receptive to things which are not to be considered. Execution में क्या हो रहा है none of my concern. Trial court का decree का
Appellate court's decree.
I want to see the trial court. Schedule of the property contains the entire plot number 2968 and out of which only 6 decimal is there. It is, that's right, schedule of the property is giving the description of the entire 2968
But
plot number and the suit property is only 6 decimal out of that.
6 decimal. And sale is also for 6 decimal.
That's right.
The leadership will firstly have the issues which were framed by the learned trial court. Page number 20. Page number 22, your leadership of the trial court judgment.
Yes, 22.
The fourth issue only I want to place your leadership. Has the defendant number 1 perfected right title and
They have
interest
given
also by way of adverse
They have
possession?
given up. They have given up this plea.
Your leadership, this was what they had contended before the learned trial
They
court.
have
for their
given up
defense.
this plea. They are not arguing on this.
Leadership may kindly have the issue number 3.
I have recorded their submission that the defendant has not been able to prove.
Yes.
But it is for the plaintiff to prove the case, and this is the relief, and this is the defect in the judgment.
Then issue number 3, has the plaintiff acquired any right title interest in real property by virtue of civil deed dated 23/11/1990? Leadership will only have the relevant portion of the trial court's order I'll place, which I had earlier also read at page number 31, where the trial court also found that the claim of the defendant of inheritance through Sumi Kui could not have been done because the marriage was itself void.
That was
So
You see
inheritance
that they have
could not
given
have
up
been-
that also. They have given up even that.
So there is no claim of the appellant then at this stage of the issue.
No, they are saying that if the suit property was
Not
purchased by Sumi Kui, there is a registered deed which is existing. Right? Then under such circumstances, with respect to the same property, if Sumi Kui has purchased a property from the legal heir of the recorded tenant, then with respect to the same property, there cannot be a
second.
second sentence. This is what he has said. I hope I have correctly got it.
Governors, the Lordship may not explicitly record a submission that we are giving up our title.
I have recorded your submission.
Even-
Whatever you have submitted, I have
Even-
recorded. Please don't interfere like this. I have dictated in your presence. Did you object? Now you want to add something to it. I
I'm
will
not
not.
adding much. I'm only saying that even if the defendant has not been able to do his title.
I have recorded that also. I have recorded even that. that if the defendant has not been able to prove his title, that will not confer the title upon the plaintiff. Correct?
There was in fact we are not given up our title, right? We will not record our concession to that.
I am not recording any concession, but this is what your argument is. The learned counsel for the respondents has referred to the schedule of the plaintiff and has submitted that in the schedule the description of the property refers to old plot number 2188 corresponding to new khata number 29 and new plot number 2968. And new municipal survey number 483 under khata number 19, measuring an area of only 0.06 decimal. Which was just a part of the property which was recorded in the name of the tenant way back in the year 1917, whose title is not in dispute. And in the survey record of 1964, the share of the vendor of the plaintiff was recorded only to the extent of 1/80.
Leadership, one more point was raised that partition was not proved.
Yes.
But there was evidence before both the courts that there was a partition. Leadership will have the appellate court's order, page 13. This is the issue number findings on issue number 3 starts from page 12. Page 13, your leadership will have.
Page 13.
Yes. I'm reading from PW2.
Yes.
PW2 has proved rent receipt, exhibit 3/A, 3/B, further stated that the suit land belonged to Bhamia Ho, son of Chota Pandu Ho, and in the recent survey settlement recorded in the name of sons of Bhamia Ho, further stated that Bhamia has 6 sons. Further stated that after the death of Chota Pandu, the suit land came into possession of Bhamia Ho, and after death of Bhamia, it came in possession of its 6 sons. One of them was Guraki, from which the plaintiff purchased. PW3 has further stated that after the purchase, Puran Chand, the plaintiff, wanted to possess it, but at the same time, dispute started. The cross-examination is important. On his cross-examination, PW3 stated that he has not seen Chota Pandu Ho, but he has seen Bhamia Ho. Further stated that Chota Pandu Ho has other sons also. Further stated that after the death of Chota Pandu Ho 50 years ago, partition between his sons had taken place. He further stated that Chota Pandu Ho has 3 sons, namely Mandua Ho, Damu Ho, and Bhamia. Further stated that Madhua Ho and Damua died heirless. So Bhamia Ho was the only surviving heir, who is the father of the vendor of the plaintiff. Further stated that the land belonging to Damu Mandu also inherited by Bhamia. PW3 has stated in spite of purchase, the plaintiff had got no possession of the land. PW3 has also stated that partition also taken place between the sons of Bhamia Ho about 10 to 12 years ago.
Who is PW2? name of PW?
PW2 is
Do not you. Do not.
you.
Who is he?
Because he is also a resident of the village, Dilyamacha, same village.
Is he anyway related to the family?
He is not related to the He is not related. But other witnesses also, PW4, if your leadership on that same
But the
page.
point is that there is no finding that there was a partition.
But because there was no legal way to prove that case, your leadership, that is why I read out those facts.
So
because
is there
that
any
would have been
scope?
taken into
Is there any
consideration.
scope for this court to hold that there was a partition?
No.
Non-consideration of evidences in its two perspectives. So I have to consider everything, whether it goes in your favor or goes in his favor.
One presumption, your leadership.
The evidence. So far as
Non-consideration of evidence in its two perspectives. So I have to consider everything. Why should a court restrict when the substantial question of law is so widely worded? Then the court will not restrict. It may go in favor of anybody. We are not concerned who is going to win.
But they are not challenged. That
They might not have, but you see the substantial question of law that you have got kicked. Is it a substantial question of law? Is it a substantial question of law? Not even mentioned.
should have been specified.
You should have assisted the court properly.
Was being in the year 2009.
So, 2009, you were not there in this profession. But whosoever has filed appeal was certainly there. Even his senior was not there in 2006.
He was there.
He was not practicing in 2006.
2002 he got involved.
So the substantial question of law is widely worded, even to come to a finding as to whether there was a previous partition.
But there is no evidence to that.
That is another thing. That is something else. But it is so widely worded.
In fact, their own feeling is that there was partition, but they have not got any evidence. But they have not said that the Gura case was not
The
alive.
appellate court has drawn adverse inference only because the defendant number 3 has not been examined. That is the
No.
only reason.
And no other Bernard descendant have examined. They have
No
not
other
examined
descendants
anyone,
have been
anyone.
examined, but he has discussed the evidence, but has not recorded any finding on that evidence.
But because
That this
partition,
finding is not believable, or these evidences are of no use. These evidences are a scrap of paper. They have no personal knowledge. There is nothing.
but Bernard, the partition can only be proved by the descendants or the
Who
family
says?
members of the.
Who says that partition
Yes,
can
will
only be
partition
proved by
not
the
say.
descendants?
Because the partition will have to be, it has to be said when the partition was held. There is no way mentioned when the partition was done and what was the share minutes among the parties which was revolved upon them.
118 share is already recorded in the record.
That is on the basis of the presumption that since there are 18 persons mentioned in the Katyan, so they would have 118 share. There is no
Board of
finding
rights
that,
are not recorded in that manner.
but they have not recorded how the court has come to that conclusion that 1 by 18 could be the share of the person, each person. They have not said so that there are total 18 legal heirs or total 18 person who would have the joint interest of the property. So therefore 118 share will be given. There is no finding, there is no pleading, there is no evidence to that effect also.
The sale deed leadership, which is Exhibit C, which they are relying on, which the question which was put to leadership that if a sale deed was executed earlier, sale deed subsequently could not have been executed, leadership. That very sale deed is in question because the vendor's name is not recorded anywhere in none of the service agreements.
That city has also not been challenged by them.
And that is one thing, your leadership, and there is a presumption in my favor because there is a registered sale deed, and the Honorable Supreme Court says that it cannot be set aside if a registered sale deed is.
Yes,
Mine is also
yes,
registered.
yes.
Mine is also registered prior to this.
But the vendor, but this fact that the name of the vendor of the appellant is not present in the survey records, that was held by.
Yes, that I have noted.
So the sale deed
That
itself.
is the reason the appellate court holds that the vendor also did not
Yes.
have a title.
So the sale deed itself is nullified, your ladyship, because they did not have the right title interest to transfer it
That's
to the applicant. So that presumption goes in my favor. Your ladyship may have just one judgment. I had brought judgments on your ladyship, the adverse possession and inheritance could not be claimed, but they have already let that issue go. So just one judgment, your ladyship, I'll just show.
you cite all the judgments. Because the cases they do not stop here, right?
This is the first judgment. This is on the point that claim of inheritance and adverse possession cannot go together. The leadership will have.
Para number.
Yes. Para number 33 of that judgment. I'll just place.
They are not claiming inheritance. The vendor is claiming.
Inheritance through Sumikui, the second wife. They said that they came in possession of the land after the death of Sumikui, and that is why Guru Bachan Singh, who is the defendant, had inherited the land from.
That's right.
So 33 says that
Yes, I read it.
the second judgment of our honorable court on the same point, your leadership, is para 18, page 11 of that judgment. Page 11.
There is no paragraph.
Paragraph is 18, related, it is continuing. Para 18. Para number 20, it starts at page 9, and that is continuing. Secondly, it was possession from that particular in para 11. The third judgment.
Page 11.
Yes, page 11. The third judgment is on the point, your ladyship, that there is a presumption in my favor when there is a registered sale deed which has been proved by the trial court. There are two judgments to that effect, one of 2006 and the other of 2021. The first judgment, para 27, 2006 judgment.
Yes. And 21 is para?
27.
Para 27. And 21 is para?
21 is para 33. There is a para 27 says there is a presumption that a registered document is validly executed. A registered document, therefore, prima facie would be valid in law. The onus of proof thus would be on the person who leads evidence to rebut the presumption. In this case, the defendant. Those are the judgments related to primary written.
And 380 Act. And should not put ends.
Yes.
Section 80.
40. Six of the Chota Nagpur Acts prohibits from any transfer of a tribal land to a non-tribal.
Section 84. Presumption as to final publication and correctness of the record. 84.
84 and 46 also.
46 is prevention from
prevention of prohibition
there is a transfer by permission of the deputy commissioner in both the cases.
Yes.
But in any suit or proceeding where a record of right prepared and published and there is a duly certified copy there, etc., such record of right shall be presumed to have been finally published unless such publication is denied by a certificate. Every entry in a record of rights published shall be evidence of the matter referred to in such entry and shall be presumed to be correct until it is proved by evidence to be incorrect. Okay. The learned counsel for the respondents. This is your submission.
Yes. Your Lordship, I have inadvertently have given the office copy, Your Lordship. That is the first.
The learned counsel for the respondents has submitted that there was enough material on record to say that there was partition, and has submitted that the plea of partition has been rejected only on the ground that the defendant number 3 has not deposed before the court. The learned counsel has submitted that 180 share was already recorded in the record of rights of 1964. He has referred to section 84 of the 29.01.2026 Act to submit that as per subsection 3, every entry in the record of rights so published shall be evidence of the matter referred to in such entry and shall be presumed to be correct until it is proved by evidence to be incorrect. The learned counsel has submitted that irrespective of the aforesaid arguments, the plaintiff has been able to prove his title to the extent of 180 share, which was 180 share in the plot number
new plot number 2968. Khata number 29. New khata
plot number 2968, khata number 29. The learned counsel has submitted that the substantial question of law is widely worded to cover any perversity which is found in the judgment. He has relied upon on the point of adverse possession. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2020 bracket close 15 SCC 218 para 33 and judgment passed in by this court in essay number 132 of 1985 page 11. To submit that it was not open to the defendant to claim title as well as adverse possession simultaneously. The learned counsel has then referred to the judgment passed by the Honorable Supreme Court reported in bracket 2006 bracket close 5 SCC 353 para 27 and also judgment reported in bracket 2021 bracket close 15 SCC 300 para 33 to submit that there is presumption in connection with the registered document and the plaintiff is claiming title by virtue of registered document executed by one of the legal heir of the recorded tenant, and the name of the legal heir as per the finding of the learned court is found in the record of right of 1964 showing his share to the extent of 1 by 8. That's all. The learned counsel for the appellant in response has submitted that even the contesting defendant was claiming title in favor of Turiho. Okay? Kui,
Sumi.
Sumi Kui, by virtue of registered sale deed. And both the plaintiff and the contesting defendant were referring to registered sale deed, and both were executed after permission of the
The deputy petitioner.
deputy commissioner. आपका सेल डीड कौन सा है?
Exhibit C.
एग्जिबिट सी जरूर दिखाएंगे. The Learned Counsel submits that in spite of the provision of the Tobacco Tenancy Act, the revenue record are not documents of that. Correct?
Yes. Cannot be the sole basis for
And the revenue records cannot be the sole basis to claim title. That's all. Concluded. See.
Lordship, I was only submitting the executing court is proceeding with the matter, and now they have deputed executive magistrate to take over the possession of the land in question. Till the date of judgment, the Lordship is pending consideration and some protection. We filed the IE as well.
What is the next date?
The next date, Lordship, is 4th February, Lordship, and in the meantime, Lordship, the executive magistrate will take it.
Arguments concluded, post for dictation. Okay?
Published. Next date is 5th.
कल लिखेंगे.
Okay.
ये रोज. You have given written submissions in which certain quotations from the impugned judgment has been, you have quoted it.
Yes, it is.
Could you please provide us the soft copy such that my typist need not retype it?
Yes, I'll provide.
Yes, please.
If the email ID of
Yes, you will get the email. Because retyping the same thing,
yes,
that will consume quite some time.
I'll do it now.
This case from Supplementary List Item 8, Second Appeal 293 of 2017.
Let us see the clause of the agreement, which is under dispute.
Full ratifying is submit one. Your Lordship need not go into the 2 months and 4 months thing because both the judgments I checked this the courts below have not returned any finding. And on top of that, there is an admission that they have paid arrears of rent during pendency of the suit. So therefore, they admit that there is a long-term default in payment of rent. So the only thing that needs to be decided at this stage is whether fixed-term tenancy section 11 will apply or not. Your Lordship, may kindly come to the judgment first.
Default is admitted.
They might dispute it matters, but I am seeing that it is admitted because during pendency they have made certain payments towards areas of rent.
In absence of any finding of default, can any decree be granted? That is at the root, and you are giving up.
I would say that it can be seen from the judgment itself that there is an admitted case of default, so there need not be any finding. This is what I want to ask.
Default is admitted
There
or
is no-
disputed?
No. We have never filed WS. It
Oh.
was decided ex parte. How can it? Only admission by way of any document. We have not
That's
filed it.
That's right. You have not filed any document.
Nothing has been.
Fair enough. Their
Admission.
case was that they were 2 months, right? 2 months. Their case was that there was default of
Default
2
of 2 months, September, October.
and September to October 2009, and suit was filed later in the year 2010 perhaps, or maybe 12, I don't
Whatever.
remember. But the rent was not paid. Correct? Now, let us see the clause of the agreement.
Also,
Agreement.
yes.
Page 15, page 5 of the agreement.
Whereas now the lessor has constructed 3 stalls, each to west, measuring as indicated schedule below on the ground floor after leaving a space, measuring so and so, on which another stall is being constructed by the lessor. And whereas the lessee now wants to have 4 stalls on lease for a period of 28 years and the rent of rupees 1100 per month commencing from so and so. And whereas the lessor has accepted the offer.
So, rent is monthly.
Yes, please.
Now next
Whereas
page.
the lessor has accepted the offer of the lessee and the parties have now mutually settled terms and conditions of the lease.
Now page 6, column 2, sorry, para number 2.
Para
The
3.
term of lease shall be 28 years, effective from 1st January 2001 and expire on 31st of December 2028.
Then 3.
The lessee shall pay rent of rupees 1100 per month for the 4 stalls aforesaid, and the same shall be paid within first week of English calendar month as per agreement between the lessor and lessee. The rent can be paid after 4 months, and within such period the lessee shall not be declared defaulter. This agreement was accepted by the lessor in view of special position and contribution of the lessee. That the monthly rent shall be payable from the month of January 2001, the date of commencement of present lease.
So monthly rent was payable,
Yes.
and as per the lease deed, it can be paid within 4 months, right? And within such period, the lessee will not be declared a defaulter.
Yes.
So, although the tenancy was on monthly payment, but for 4 months, you cannot be declared as a defaulter.
And that was also because there was some special clause.
That's it.
It was something we had given that was
But
not
beyond 4 months,
beyond 4 months to be defaulter.
defaulter. The case was that you have not paid this rent from September 2009 onwards.
The cause of action has to be seen, Lordship.
Yes, that is why cause of action, we have to see that cause of
Yes,
action.
cause of action.
And this 2 months, September 2009 and October of 2009, you have not paid that.
That is the
So
cause.
even if there is a deferred payment of rent beyond 4 months, you can still be a defaulter.
My submission is, I will be a defaulter, no doubt, after if I don't pay after 4 months.
Yeah.
Nothing on that.
Okay.
If the clause had not been there, only after 2 months, as per BBC Act.
Okay.
Now, Lordship, my submission is, whatever goes, that goes from the pleading, only by the plaint.
Certainly.
In the plaint, Lordship, they could not prove, in both the courts, concurrent finding is there, that there is not the petitioner is not a defaulter for 4 months, as per the lease, and therefore he could not have been defaulted.
But that is not the clause. You were still supposed to pay once the 4 months. You will not be declared a defaulter for a period of 4 months.
Yes.
But after expiry of 4 months, if you do not pay, then under such circumstances you will definitely become a defaulter.
But from where this is coming?
This clause?
No, that is not this clause. The pleading should be there that I was not paying from such and such
It
date
is there.
till the filing of the suit.
It is there. It is there. Just let's have a look at it. Let's have a look at it. Court fees of rupees 12 months, right? 13,200. They say, and para number 5.
No, just
And did not pay the rent till September 2000 since September 2009 up to date.
as per the terms and conditions of tenancy, the defendant should have to pay the regular rent regularly. The defendant became irregular in payment of the rent and has paid the rent up to the month of August 2009 and on 18/9/2009 and thereafter did not pay the rent since September 2009 and up to this date became a defaulter in the IUF. That further the plaintiff number 2 to 4 and the husband plaintiff number 1 died on such and such, leaving behind the plaintiff in default. Now, Lordship, what my submission is that the father was alive. The father, therefore, the honorable both the courts have come to a conclusion that there was no tenancy with me. The father was the tenant, was the landlord, and he was being paid the rent. How come these people will come to know at the time of their when the father was alive? This is what both the courts have considered, that this was
But
premature.
on the last occasion you have said that you have no dispute so far as that point
No,
regarding
no,
landlord.
as of now, since not from the pleading of the case, as of now they are naturally the tenant, landlord, and I am the tenant.
The
But when the father was alive,
father died on 4/2/2010.
yes,
By this time you had already become a defaulter.
what they are saying from September 2009, they are taking my default from September 2009 when the father was alive. Therefore, the entire case is false, premature.
This is September 2009
Yes.
when the father was alive.
Yes.
So 4 months expired in the month of December.
December.
But still you did not pay.
That is what their case is.
Yes, because this is their case and in absence of written statement you have nothing to say.
No. Therefore, Lordship, what I am submitting, I am only supported with the trial court judgment. Since the trial court, it was passed ex parte, it did not appear in that case also.
That's right.
And the trial court judgment as well as after improvement in the appellate court judgment. It was improved, the prayer was improved. It is from this to this period, the period was enhanced, September to December it was enhanced, but in spite of that, they could not succeed. And this is entirely matter of fact. It has been considered by both the
What
courts.
is the finding of the court?
Yes. In hurriedly Lordship, I must say they have filed this. Father के death के बाद फाइल होता तो कोई दिक्कत ही नहीं था इसमें. The findings Lordship starts from. अच्छा, yeah.
They have given you written submissions also. You have given your written submission.
Written
You have
submission.
still more to say? You have still more to say? Let him finish. Because
हाँ
yesterday
इस
he
पे
has
तो हम
not
लोग थोड़ा सा इस
finished.
पॉइंट पे हमको भी बताना पड़ेगा उसको.
So far as the findings of the court is concerned, Mr. Your Lordship, may kindly come to running page number 41.
Yes.
Last paragraph. From exhibit 4, first of all, it became clear that there was a fixed term tenancy of 28 years effective from 1st January 2001 and has to expire on 31st of December 2028. This fact is nowhere disclosed by the plaintiff that the tenancy for 28 years of fixed term. It further appears from exhibit 4 that the lessor has agreed upon the terms that rent given be paid after 4 months, and within such period, the lessee shall not be declared defaulter. In the present suit, the cause of action for the suit, as stated in paragraph 10 of the plaint, is that non-payment of rent by the defendant for 2 months, that is for September and October 2009, has arose the cause of action for this suit, which is not in consonance with the indenture of lease, that is Exhibit 4, in which it was agreed that default in payment of rent up to 4 months shall not declare the defendant as defaulter. Again, it is admitted fact that the suit premises has been leased out to the defendant by one Omia Kumar Banerjee for 28 years since 1st January 2001. As per plaintiff's case, the defendant had stopped paying rents in September 2009, whereas the said Omia Banerjee has died on 4/10/2010, leaving behind these plaintiffs as their legal heirs. It shows that during the lifetime of Amia Banerjee, defendant has not paid rent, but the said Amia Banerjee, that is father of the plaintiff number 2 to 4 and husband of plaintiff number 1, had not taken any step for eviction of this defendant. Again, whether the plaintiffs are still landlord, this has not been recognized by this defendant, as no rent ever paid to the defendant to these plaintiffs, nor the plaintiffs are given any notice to the defendant in writing to demand the rent. As such, the defendant was liable to pay Exhibit 5 series of the rent receipts during the lifetime of Amia Kumar Banerjee, the original lessor. If I may stop here for a while. So, the learned trial court has come to a finding that no rent was ever paid to me, even after the death of Amia Kumar Banerjee, and thereafter this suit has been filed. So, this is a case of continuous default. So, there is no question of 2 months default or 4 months default. Thereafter, no rent has been paid to me after August 2009. And if you Lordship may kindly come to the first part of running page number 42. The learned trial court has come to a wrong conclusion that the suit has been filed only for default of September and October. There is a clear statement, if your Lordship may kindly come, if your Lordship will see para 10 of the claim, there is a clear statement that there is a default for 4 months starting from September 2009 to December 2009, and thereafter this suit has been instituted. Otherwise also this argument is not tenable because in light of the non-obstinate clause in the Rent Control Act. However, this finding is incorrect is what I am trying to show. And now, if your Lordship may kindly come to the appellate court's finding, running page number 30.
You see the non-obstant clause, we just have a look at it. BBC. Two 2001 Act,
Yes,
section
section 11.
no. Section 11. Section Section 11.
Notwithstanding anything contained in any contract or law to the contrary, but subject to the provisions of Industrial Disputes Act 1947 and to those of Section 18, where a tenant is in possession of any building, he shall not be liable to eviction therefrom, except in execution of a decree passed by the court on one or more of the following grounds. Now, ground D, where the amount of 2 months' rent lawfully payable by the tenant and due from him is in areas by not having been paid within the time fixed by the contract or in the absence of such contract by the last day of the month of next following that.
Within the time fixed by the contract.
Yes.
So this contract has to be read along with this provision. The time fixed by the contract is 4 months. 4 months you have a hiatus. You can be a defaulter continuously for a period of 4 months for the month of September. Right? September of
Yes. 4 months is the if both the contract and the act is read harmoniously. 4 months is the time fixed for the payment of default of 2 months. That is
Yes.
September and
In spite of default,
Yes.
there is some leeway given to you
Yes, yes.
that you can pay it after 4 months. We
Yes.
will not treat you as a defaulter. That is the agreed. So the agreement has to be read along with the provision of the law. Not only on account of on agreement, the case would not have been decided. This particular clause was to be read along with it.
Then the next clause is minus of fixed term tenancy.
Now, let us see further in the light of my aforesaid finding.
Thus, in the light of my aforesaid findings, I come on conclusion that these plaintiffs have failed to establish landlord-tenant relationship between the plaintiffs and defendant, and also they have failed to establish any cause of action for the present suit as mere defaulter of 2 months' rent, as pleaded in para 10 of the plaint, is not sufficient to hold this defendant defaulter as per section 11(1)(d) of BBC Act, because the written agreement between the said Amia Banerjee along with the defendant clearly keeps away the legal provision of 2 months. Hence, I find there is no cause of action as such available before the plaintiffs to file this suit. It is worth to appreciate the conduct of the plaintiff, as the plaintiffs are nowhere either in their pleadings or in their evidence have disclosed about the lease for a fixed term tenancy of 28 years, and have also nowhere disclosed that there was a provision in such lease agreement that the lessee, that is the defendant, would pay rent even after 4 months, and within such period the lessee shall not be declared defaulter. This shows that the plaintiff tried to suppress the material facts with this court regarding the nature of tenancy.
What do you have to say? That there are 3 parts.
Yes.
What do you have to say? Because there is a question of law in connection with landlord-tenant relations. What do you have to say so far as the point of landlord-tenant relations?
Landlord-tenant relation, all I am saying, Malas, is that atonement is not necessary after the death of, because the agreement also provides that the lesser will include his legal heirs. So I will automatically step into the shoes of the lesser. And I have given the judgments also, it is included in my written submission also. They also did not dispute in their written submission, that is why first day only I asked their dispute. Secondly, minus the law, the trial court has come to a finding that no rent has ever been paid to me.
Or to the father also.
Yes, even after I stepped into the shoes of my father. But despite that, there is no finding that there was a default of 2 months or 4 months, or more than 4 months. The learned trial court has given the judgment only on the assumption that the cause of action that is stated in the plaint is only for 2 months, which is also an incorrect finding. Because as clearly
the
stated,
finding of the court that you are not a defaulter, you cannot be declared as a defaulter, is there. It's very much there. That you cannot be declared as a defaulter.
only based on a statement made in my plea. But the first paragraph, the learned trial court has come to a finding that no rent has been paid to me. If no rent has been paid to me, then he is a defaulter.
That's right.
If your lordship will kindly see the
Now,
plea.
so far as fixed term tenancy is concerned, what do you have to say? What about the appellate court's judgment?
Yes. But why this confusion arose by us? Because the learned, only one thing is about the learned trial court session. Why this confusion arose? Because your lordship will see the plain for me. Just one paragraph.
Yes.
Paragraph number 10.
Yes.
That the cause of action for the suit arose on 31st December. This is amended. The last date by which the rent for 4 months, that is September to December, became due, and on first of each of the subsequent months when the defendant became defaulter on so and so. So the learned trial court gave a finding based on the unamended plaint that the default is only for September and for 2 months, which is not in consonance with the agreement. So therefore, I know that is what I was trying to point out. It was not amended before the trial court. However, the dates are given. From the dates, it is clear that there is a default of 4 months.
This was amended before the appellate court.
Yes.
So appellate court must have taken note of this amendment.
Yes.
How the appellate court deals with it?
So Lordship, may kindly come to running page number 30.
Three zero.
Yes.
Yes.
Be that as it last para 14. Be that as it may, it is the pleading of the appellant that the cause of action for the suit arose on 31/12/2009 after rent for 4 months from September to December 2009 became due and payable, and when the last demand for rent made on 1/8/2012 was refused by the defendant. The plaintiff appellant, however, during pendency of the appeal, filed an amendment petition stating to have received a sum of rupees so and so and again rupees so and so for as areas of rent as has been deposited by the defendants. No detail of payment and month for which rent was paid has been mentioned. It is further manifest from perusal of indenture of lease exhibit 4 that rent could be paid after 4 months, and within such period the defendants would not be declared defaulter in view of special position and contribution. It is further manifest that the rent of the suit premises was subject to enhancement by 15% after every 10 years, and as such monthly rent for the suit premises would come to rupees 1265 only. Thus, from shifting of evidence and material brought on record, it is found that the lessor of the suit premises, Shri Amiya Kumar Banerjee, had leased out the suit premises for a period of 28 years and was not liable for eviction on ground of non-payment of rent during the period of 4 months. The defendant was liable to be evicted from the suit premises only upon violation of terms of conditions for use and occupation of the suit premises.
Was there any negative covenant
No.
that he will not be evicted?
The cause of action has been stated to have arisen on 31/12/2009, while as per the terms of the agreement, the defendant was not liable to be evicted for non-payment of rent during the period of 4 months. Thus, the cause of action could not have arisen on 31/12/2009. Now, this is the finding of appellate court, despite amendment in plain that the cause of action arose on 31/12/2009. So, 31/12/2009 is taken as the cause of action. It completes the 4-month period as prescribed in the agreement. August, September, October, November, and December.
That I accept.
Moreover, the last rent receipt produced by the plaintiff do not appear to bear the genuine signature of the defendant, while there is no endorsements as regards the advance and adjustment of rupees 2,000. The plaintiff has failed to make any assertion in its pleading as regards the adjustment of the advance payment or towards the enhancement of rent by 15% after every 10 years as stipulated by Exhibit 4. The enhancement would the monthly rent to rupees so and so and deposit of rupees so and so substantiated that as well. From the perusal of Exhibit 4, it is further manifest that the suit premises comprising of 4 months was leased out by Amiya Kumar Banerjee from 1/1/2001 for 28 years, who himself died on 4/2/2010. The pleading of the plaintiff that no rent for the suit premises was paid after August 2009 does not appear to be endorsed by the lessor during his lifetime. The deed of lease itself stipulates that the ground for eviction has no clause for eviction of the suit premises on the ground of personal necessity of the plaintiff. Thus, the plaintiffs do not have any cause of action for eviction of suit premises on the ground of personal necessity, overriding the terms of indenture of lease. Be that is as it may, the intention of the lessor appears from the recital of the lease deed that the lessee defendant was given a security of tenure of tenancy due to long-standing relationship between the parties to the lease. The learned trial court as such was correct in arriving to the conclusion that the plaintiff had failed to prove any cause of action and the same was not maintainable in the present form. The plaintiff was rightly held to be not entitled to leave custody. This is the finding of the appellate court. 31/12/2009, 4 months is already completed. So to come to a finding that no cause of action arose on 31/12/2009 is incorrect. Secondly, also even before the trial court, even though the amendment, the claim was not amended, In the previous paragraph, I have stated that the rent has not been paid since August 2009 till the filing of the suit, which is more than 3 years. So therefore, these aspects have not been taken into consideration, only relying upon the terms and conditions of the contractor without looking into the Rent Control Act.
These arguments has to be considered on the with substantial proof.
So there's also a finding Manas, that he is not liable to be evicted on the ground of personal
That
necessity.
is only
There's also a finding that he is not liable to be evicted on the ground of personal necessity because there's no provision in the contract. So once your lordship comes to a finding that the Rent Control Act will prevail over the contractual obligation, then all of these things can be looked into.
the finding of personal necessity has been established. Your claim of personal necessity has been established.
I was not even given an opportunity, it is not considered at all. There was a pleading, but the learned both the courts below came to a finding that since it's a fixed term tenancy, is not liable to be evicted on these grounds.
You took a specific ground of personal necessity. You took a specific ground of personal necessity.
Yes, madam, it was cleared in the plaint along with the default in payment of rent. And only because it is a fixed term tenancy, all of these grounds have been not taken into consideration.
And what do you have to say so far as fixed term tenancy is concerned?
Fixed term tenancy, madam, as already stated, is a direct judgment of the Honorable Patna High Court, specifically deciding the same issue. And why that judgment will be applicable? Because the Jharkhand Rent Control Act is word to word adaptation of the Bihar Building and Rent Control, the 2001 Act. It's an adaptation of the 1982 Act. And there's a division bench judgment as well, and there's a single bench judgment as well. Also,
Yesterday
Madam,
you
Lordship.
have received these judgments, right? Yesterday?
Yes, it's
Because I can't the judgments. A bunch.
the Lordship may kindly come to
This
the-
one.
Yes. Last judgment, Madam. The very last page of the complaint.
1992. Otherwise also it is of undivided Bihar.
Yes, yes.
1992.
The very last page of the compilation, 137.
Yes.
In view of the decisions of the Supreme Court, I am unable to accept Mr. Chatterjee's contention. I accordingly find and hold that in a lease for a fixed term also, where the tenant is paid, rent is payable on a monthly basis, the provision of Section 11(1)(d) of Bihar Rent Act is equally applicable as a ground for eviction of the tenant, notwithstanding the absence of any forfeiture clause in the agreement. I should also like to state, however, that I do not wish to say anything as to what would be the position with respect of a lease for a fixed term where the payment of rent is not on a monthly basis but on monthly. And thereafter, the single bench, another single bench judgment, which I had relied on yesterday.
Principle on which lordship this judgment is based. Subsequently, in 2001 lordship, the entire principle has changed.
Which division bench judgment?
This was a division bench, and a single bench, page relevant is page 117. It starts from page 114.
Yesterday I thought that this would be the first case to be taken up. Whenever there is a spillover,
Lordship.
the last parted matter should be taken up first. In the morning also both of you were not here. Otherwise I would have called this case only. Because बहुत दिक्कत हो जाता है.
हाँ दिक्कत होता
I was reading this brief. Anyways, which page?
Page number 117,
117.
paragraph number 9.
Yeah, that you have already listed. That's all.
Legally also, my love, the section 11(1)(d) and 11(d) is
So on the point of default, at best you can say that there could be a remand on the point of fixed term tenancy. But so far as the point of default is concerned, how do we enter into that? That is not the substantial.
that is a substantial question of law, because there is no finding with respect to default.
But that is not strange.
But there is no finding with respect to default because the court came to a conclusion that it has to be dealt with by the agreement. The court had come to a conclusion that it has to be taken into consideration in accordance with the sections of the Rent Control Act. then there could have been a finding of default. So there's no finding of default because of that. So therefore that is also covered in that section.
अब 1:30 बजे
मंडे को
आज क्या है फ्राइडे
आज कल फ्राइडे है कल उस
फ्राइडे
हम रिक्वेस्ट कर रहे हैं उसको कल नहीं हो पाएगा बहुत डिफिकल्टी आज भी दौड़ते हुए है कल मंडे को 10:30 फर्स्ट केस रखते
नहीं कर सकते मंडे को ऑलरेडी एक केस
तो ट्यूसडे रख दीजिए शॉर्टेस्ट पॉसिबल टाइम बिकॉज हम जो जजमेंट दिए हैं सारा कवर इनका पॉइंट में है हम ज्यादा
मंडे
टाइम
को ऑलरेडी एक दो केस रखे ना मंडे को ट्यूसडे को मंडे को
हाँ
The arguments of the appellant has concluded. The learned counsel for the post this case for the argument of the learned counsel for the respondent on Monday, 10:30 first case.
Can I make a request for item 25? This is a matter listed in order 41.
We have also given the written notice of arbitration.
Yes, sir. अरे भैया आपको दोनों सॉफ्ट कॉपी अपना दीजिए
हाँ सॉर्ट कर
वो दे दीजिए कम से कम हम लोग बस स्टेनोग्राफर लोग से बहुत परेशान है आपने भी दिया है ना वो you give your soft copies.
Can I make a request for item 25 taken up on Monday? I have some personal reason. These are matter fixed for final hearing in the ordinary bench. Item for Monday.
We'll let you know.
One matter of supplementary 4 years.